I'm just sending you the H289 most recent amendment draft that we've been working on
Okay, great.
for you to post.
All right. And
Sorry
we
to
are
interrupt.
live.
Okay, so we are the Senate Government Operations Part 2 on May 4th. It's now 1:30 and we met for a little while this morning, but we're meeting right now around the OPR bill. I believe the number is H289. And there are a couple outstanding issues. I believe we except for the issue of the NDs and the inventory that we have are all okay, right? Am I right about that, committee?
So I believe so.
Okay.
Can you just remind me? I'm sorry. Does
Cameron?
this include?
Okay.
Oh, sorry.
For the record, Ameren Abergele Legislative Council, I don't believe the committee has done a walkthrough of the language towards the end of the bill.
Right. I think you're
Okay.
right.
Even though we've discussed it a couple of times at least, I don't think the committee has seen the language in the bill yet for
okay.
those.
Great. Yeah, thank you. Yeah, Senator Ram.
Does this still include MMA? Is this bill? Okay. Okay, good. Okay.
So it would be the bill as it came over from the House, plus the MMA, plus the Jill Olson language, plus the Ameren, remind me.
The last section was amending the unprofessional conduct section of Title III to include that language around a process for if an individual has a conviction.
Right. So I would suggest that what we do is walk through the parts that we haven't seen yet. Did you just lose me?
Nope, you're here.
I have no idea what just happened here.
You're having challenges in Putney.
Oh my God. All I wanted to do was go to our website here and okay, there I am. Okay.
So is there a version on our website yet that includes what we're talking about? All I have on the website for 289 is that's passed by the House.
I just posted it, Senator Polino. You can go
Okay.
ahead and refresh and it should be there.
Okay.
Is it, okay, refresh.
H289 SGO amendment. Is that what we're talking about?
Yes.
Yeah.
Yes.
Correct.
MMA and boxing.
Uh-huh.
Right.
Okay, great. All right. Ameren, would you like to walk us through those parts?
Yes. So the new sections from the last time you reviewed this amendment, which would have been, I believe, draft 1.4. So this is draft 1.5. On page 23, you'll see a new section header that's highlighted with the reader assistance heading home health nursing. So there
Ameren, I've never heard anybody else use that term, reader assistance heading. It's very helpful.
Yes, that is the term that our editors use.
Okay.
I've gotten used to saying it. So you'll see this is numbered section 19. The numbering in this section will look a little odd because it is amending sections from session law. So there was an act in 2020, Act 90, which was then amended later by Act 140 in 2020, and then again by Act 6 in 2021. So if you scroll down to section 17 on page 23, this is regarding the Office of Professional Regulation, Board of Medical Practice, out-of-state healthcare professionals. You'll see on page 24 that at the request of Jill Olson, the healthcare professional who is able to practice under this section for those healthcare professionals coming from out of state can be working as part of the staff of a licensed facility, which is on page 24, or other healthcare facility as defined by Title 18, Section 9432. And that was because there was a concern that licensed facility does not cover home health nurses. And so this was the requested addition to this session law to permit those home health nurses to practice under this other healthcare facility. So that's been added on page 24 in subsection A, and then again in subsection B. And those were, oh, nope. And then again on page 26, which is in section 18 from the prior session law act. And this has to do with those healthcare professionals who are practicing under inactive licenses within that 3-year period following their license expiring. So once again, we expanded who is eligible to practice under this exception.
So is everybody okay with this change?
Yep.
Okay. All right.
All right. And so then the next addition is a new section 20. This is adding on to section 129A in Title 3. This section is unprofessional conduct. And you'll see this is under the circumstances where any one of the following items or a combination of items, whether the conduct at issue was committed within or outside the state, shall constitute unprofessional conduct. That's at the bottom of page 27. And then if you move into page 28, you'll see subdivision 10 is conviction of a crime related to the practice of the profession, or conviction of a felony, whether or not related to the practice of the profession. And then there is new language that was suggested by the Office of Professional Regulation. If an individual has a conviction of concern, the board or hearing officer shall consider the following in determining whether to deny or discipline a license, certification, or registration to the individual based on the following factors. A, the nature and seriousness of the conviction. B, the amount of time since the commission of the crime. C, the relationship of the crime to the ability, capacity, and fitness required to perform the duties and discharge the responsibilities of the profession. And D, evidence of rehabilitation or treatment.
Anybody have any, or Lauren, did you work with our friends from CSG with this?
Yes, I did. For the record, Lauren Hibbert, Director of the Office of Professional Regulation. I just wanted to thank the committee on this language. The office supports this language, and it was after the testimony from CSG last month, and we think this is a good change. And we
Thank you. Senator Polina, I saw you had your hand up.
Yeah, it's sort of a comment or an observation. When I read this, it seems like it's pretty subjective. Like it gives you a lot of flex. I don't know whether it's you personally, but it gives the office a lot of flexibility on deciding whether, how bad a crime was, that kind of stuff. I mean, you see it that way too, right? That was your intent?
Yes, Senator Polina. Yes, it was our intent to have it be fairly subjective. If you start creating black and white lists for crimes, it's very easy for us to miss a crime from another state, since we do license a lot of people who may have been convicted of a crime in a completely different state than here. And then another problem is that we really want to be able to look into the gray. This is not a black and white issue, it's a gray issue. And so the subjectiveness of this tool will be used to argue on both sides of whether or not the crime was related to the practice of the profession. And I think it's important to remember in this context and in all of our contexts that there is due process, there will be a hearing, there is an appeal process, 2 layers of appeal on top of that hearing. So somebody has the ability to really exercise their due process if they feel like the subjectiveness is applied unfairly to them. But I think the subjectiveness is important. I think the timeliness and the signs of rehabilitation, those are the things that are going to be looked at most frequently. How long ago you committed the crime and what you've done since you've committed the crime are probably the most important factors.
And I think that it always has been somewhat subjective, but this gives some guidelines for looking, for examining it, is the way I read this.
You're absolutely correct, Senator White. This codifies in statute what the office is currently doing. And that was the biggest feedback from CSG, was that we were doing the right things, but an applicant wouldn't know what we were doing, and therefore we looked like a black box, and a scary black box at that. So this makes us more transparent about our process and really informs an applicant of what we intend to look at if and when they apply.
And it puts it in statute so that the next director that comes in will have some guidelines.
Whoever he or she may be, I wish them well. But yes.
Senator Clarkson?
I hope this isn't announcing anything.
Oh,
Lauren.
no.
Yeah, good. Huh. We've just gotten you. We
Yes,
want-
it's true.
My question is, I think we're conflating things here. I mean, this to me is unprofessional conduct. This is conduct as a holder of a current license, not an applicant who may have a criminal record. So to me, those are two different issues, right? I mean, this is addressing unprofessional conduct while they are a license holder in the state of Vermont.
So I think you raise a really good question. It's just the way that our statutes are constructed. They're a little funky. 123 VSA 129A applies to an applicant or a licensee. And so we can deny an application on that base, on any of the bases in there. And the front part of the statute, I'm going to just pull up the language. If you look at page 27, line 14, or line 15, it says when that conduct is by an applicant or a person who later becomes an applicant, it may constitute grounds for denial of a license or other disciplinary action. So this is where all of the bases for denial of a license are housed, unless there's a profession-specific basis, which is in the profession-specific statutes or rules.
So that's frustrating to me. This does not, I was assuming that unprofessional conduct was for all your license holders across all the professions that you represent. Is that not the case?
It is the case.
Okay.
It's both. It's serving two purposes.
Okay. So it also is addressing applicants for a license who may have a criminal record.
Yes, that is correct. And it always has. It always said that we would have the ability to deny a license on the basis of a misdemeanor related to the practice of the profession or a felony. That is
right, but that's related to the profession. As we've discussed, the felony or misdemeanor may have nothing to do with the profession, may have been when they were young people. I mean, so we need to remove its connection to the profession. It's right. Is that what this section does?
No.
This section does not remove the connection to the profession. It maintains the connection to the profession, which I think is an important public policy. And it clarifies.
Holders. I get that for license holders, but for people who are applying.
But if you committed a crime that's related to the practice of the profession, I'm trying to think of something.
I know we always think of the Deacon Barber of Fleet Street. So
or embezzlement for a CPA.
Yes, embezzlement if you're a tax accountant, right? So if you had a fraudulent check or you embezzled from your employer and then you decide, you know what, I'd really like to be an accountant. And you go through school and you don't choose to do our second chance determination process, which this legislature put into place last session, and you go to school and you put in your application, we've always had to prove that that embezzlement charge was either a misdemeanor related to the practice of the profession or a felony. And by policy, we almost always require the felony to be tied to the practice of the profession. What this language does is it really shows what our analysis is going to be when we receive that application with that crime disclosed, and gives the person the knowledge that we are going to look at the time it's been since their application, the
Right.
what they've done for rehabilitation, all of those good things.
Yeah. No, I got that. Okay, then it's sort of a misnamed, I mean,
I think, Senator Clarkson, the issue arises with the title on line 13 of page 27 of unprofessional conduct. And unprofessional conduct seems like it may apply only to a licensee, but it actually applies to an applicant and a licensee.
right.
Which
So
is
it-
what that subsequent section
Right.
refers to.
Right. No, I hear you. It just assume the title would lead one to believe that it only applied to current license holders.
Okay, are we okay with this language? I think this language
Yeah.
makes it clearer that whoever is sitting there has to take these things into consideration. So the nature and the time and the relationship. And I think that's really important to do. And Senator Collmore.
Thank you, Madam Chair. So you've kind of touched on it already with Senator Clarkson's question, but I was going to ask Lauren if she could give us an example of someone who had a felony that you would deny the license to, and then one in which, given certain circumstances, you would allow a license to be granted. And you've already sort of said one about the CPA and the embezzlement, because I think everybody would agree that that offense, whether it was a misdemeanor or a felony, touches the occupation for sure. I mean, that's part of what an accountant would do. So I don't know if that helps.
So, Senator Collmore, is it okay if I use two different felonies? It's hard for me to think of a felony that would count for one and not for the other, just off the top of my head.
Sure. Yeah.
So let's say that you were registered as a pharmacy technician and you diverted narcotics from the pharmacy. And then you were convicted of diversion, of fraud and deceit, because it was a significant amount of narcotics. And then you decided to go to nursing school. We would consider that a felony related to the practice of the profession. But we would not consider it, I've done it, I figured it out, we would not consider it a felony related to the practice of real estate.
Okay.
And given these guidelines, am I to assume that you may or may not deny that license to the pharmacy technician who now goes to nursing school if he did it when he was 19 years old, was a pharmacy technician, and he's now 42 going to nursing school and has had no subsequent convictions or charges or anything like that?
That's correct. He may have shown evidence of significant rehabilitation, and we may decide not to completely deny him a license, but to warn his license so the public is aware, any future nursing employer was aware, or we may decide to grant his license in a completely unencumbered manner, meaning that he could practice freely without any warning to the public of his previous conduct when he was a pharmacy technician and he diverted.
Right. So this says you're going to take all those into account. And it
Yes.
says whoever is sitting on these boards and making these decisions, whether it's the director or the boards, they need to take these things into consideration instead of just flat out denying or not denying.
That is correct.
Thank you.
So
Thank
is any more questions about this section, or are we okay with it?
Can I ask, this may, I don't want to go off on a tangent, but remind me what the second chance thing is about.
Oh, sure.
Because I don't know if that relates to what we're talking about, I think.
Yes, I think it's one of my favorite things that we've done together. So I'm happy to talk about it. It happened last session, and it's where someone who is deciding whether or not to go to nursing school. Let's go back to our analogy of that, our hypothetical of the pharmacy technician who has the diversion. He would be able to ask before he invested in nursing school, which is quite expensive, with a $25 application to our office, whether the crime that he's been convicted of will preclude him from licensure if he had all the qualifications. So it's a way for somebody to know before they seek out the education if their specific situation will preclude them from licensure. So, and it's been live now for a month and 4 days. I think we've had about 20 of the applications.
Oh,
Really?
Yeah, and I'm really excited about it. I think it's a really wonderful thing to do to show the world that we're open and that we want to engage with people on these topics.
But in that case, they just get a yes or no answer. Do you go through the whole process that this bill implies, looking at the different levels and whatnot?
That language, the language in this bill is modeled somewhat. It's a little tweaked. We've learned some things even since last session. It's a little tweaked after the conversation with CSG, but it's modeled very similar, same variables, type of crime, evidence of rehabilitation, time since conviction. So very similar variables, same team does the analysis, whether it's a predetermination, second chance determination, or an application determination. And we try and keep as much consistency in the office as possible so that.
And that really makes you happy, right?
Everyone makes me happy.
That thing, having done that made you happy.
Oh yeah, yes. This has been a big, I have felt very passionate about this. So yes, this is something that makes me very happy. I am a former public defender and had to counsel many people on the results of their convictions in housing and employment. So this is something that gives a lot of transparency to folks. And I think this is very good public policy.
Hear, hear. It's great. I'm so glad you've already had cause to use it. So that's terrific.
so are we all okay with this section?
Yes.
Yes.
Okay, great. Let's move on. We have two more. Did we come to any conclusion about the death certificates? Mr. Englander, were you satisfied with the training and the field experience that NDs receive in relation to what MDs receive?
So good afternoon. My name is David Englander. I'm the Senior Policy and Legal Advisor with the Commissioner of Health. I do want to start with this. What I started with a few weeks ago when I appeared before this committee, which is that the onus should be on the NDs to provide sufficient information that they have the training, education, and experience to make these very complex determinations. I did not see that in the testimony that was presented. I saw, I didn't see a curriculum, I saw a series of conclusions. So it's not that there isn't information available, but I didn't find it in the testimony itself. And I have no interest in picking apart the testimony, but there were a few things, there were a few misrepresentations made, I assume unintentionally. It depends what the word preparation of a DNR means. It says that naturopaths are allowed to prepare a DNR. They're not allowed to sign DNRs in Vermont. There's also representation that other states allow. That other states allow NDs to sign death certificates. Among other states, Maine and New Hampshire are mentioned. I only looked at those two states. Their laws look like our laws. And I contacted their Office of Vital Records, and both of them indicated that they would not allow MDs to sign death certificates. So I guess that the department is prepared to continue to hear more information and to opine on it, but it is not satisfactory to the department at this point.
Okay. Dr. Rousseau, do you want to just comment about the New Hampshire and Maine and what happened there?
Sure. So I wasn't able to get in touch with the Departments of Health in New Hampshire and Maine, so I resorted to their statutes. Their statutory language is somewhat similar to ours, but it is a little bit more expansive. And it does say basically that reports would be accepted if within their scope of practice. I don't think that's the exact language, but that's what their language indicates. In regards to DNRs, looking at the statute again, it is unclear to me whether NDs can sign them or not, because in one part of this definition, the definition of who can sign a DNR is defined as clinician. However, in the actual chapter on DNR, clinician is not used. It's healthcare provider. And looking back into the relevant part of the statute for the definition of healthcare provider, it's a different definition than is used at the beginning of the section in Title 18 for DNRs. So I don't need to go into that in too much detail because that's not what we're focused on today. However, in regards to other states that do allow NDs to sign death certificates, I think it would be, if there's concern about Maine and New Hampshire, that I think contacting some of these other states such as Arizona, Washington, Oregon, California, where there are many, many more NDs practicing than are practicing in New England, you will see that they are signing death certificates and they are accepted by their departments of health. In regards to specifics on training for NDs compared to other providers, the requirements are, there are not a lot of requirements for MDs as defined in the liaison committee. This is really something that's more on the job training. So I would like to know where the specific information that PAs have had to put forward and NPs have had to put forward and MDs have had to put forward to demonstrate their education, where we're being asked to do the same thing.
Yes, that I think that's a legitimate question. If PAs can sign, did they have to prove that, and NPs can sign, did they have to prove that did they have to make a case to the Department of Health in order to be allowed to sign?
If you're asking me, Madam Chair, that's long before, that's long before my time.
Well, I don't know that we're going to solve this today. And I mean, I have my prejudices here about what we should do. I don't know that the committee would even agree with me. And I always hate to do anything that Lauren doesn't agree with. But I'm going to suggest we add the term naturopathic physician to the section of law that allows the the signing off of death certificates. So,
yeah.
Other committee members, Senator Clarkson.
Yeah, I just would love to find out where there are more naturopathic physicians. Certainly if a PA can sign off, it strikes me that an ND should. I think they're sort of comparable. So I'd love to find out about Oregon because I'm inclined to allow it as well. But I'd love to find out more information about the states where there are many more NDs than there are here in the Northeast. Did we find that out and I'm just not remembering it? I thought.
No, we just know that they do. We don't know what their statute says or how they do it, but we know they do it.
But yeah, that's right.
Senator Collmore.
Thank you, Madam Chair. I think I'm going to side with the Department of Health, so I'm not in favor of this.
Any other committee
I think
members?
Lauren had her hand up though.
Oh, Lauren, I'm sorry.
Madam Chair, if you want to hear from other committee members, that's fine. I just was trying to indicate I wanted to say something.
Yep.
So again, like I've testified previously, I think it's really important that we get an index of where naturopathic physician, APRN, physician's assistant, and physician are used in the statutes and look at this on a comprehensive level. There's two ways to approach this problem. I guess there's three ways to approach this problem. The committee could amend the language today. The committee could have the index done, which the Office of Professional Regulation supports. There is statutory inconsistencies throughout the statutes. There are people with overlapping scopes of practice, but just because there's areas of overlap doesn't mean they completely overlap. And then there's very large differentiations in training. An APRN has different training than a physician, and a physician has different training than a naturopath, and a naturopath has different training than an APRN. And some of those trainings overlap, but there are differences, and they should be understood and really contemplated. And the third suggestion is that this is starting to feel a bit like a scope expansion or scope review. And this committee did pass a process to do that last year in Chapter 57, which is a way for that you could assign the task to the office to do a review, and we would look into other states' training, et cetera, and see whether this was appropriate and make a recommendation back to this committee and the House committee and the both bodies, committees of health. So that would be another process that would slow it down for sure, but then would be analytical, and we would be able to review what we were able to find on training and scope.
Committee people? Senator Clarkson?
I would, well, Anthony hasn't spoken yet, so I mean, I'll come, if I can come back after Anthony, that would be great.
Sure.
Well, I was just gonna say, I lean towards allowing it as well. But what Lauren just described might be an alternative, which would put it off till next year, I presume. But that's better than saying no, I think.
Well, I would agree with you, and it would really be great if that could also include, as you do that scope of practice study, if it would also include finding every place in statute where it's mentioned and have us fix it comprehensively, because I think we could kill two birds with one stone, as it were. Don't know who'd pronounce the bird dead, but
Well, if I could just say, I'd really like legislative counsel to do the indexing, and I'll work on the report, because that would be a mammoth task. And I think what will happen when we do the indexing will be that we'll find many of these questions. This is just one of several. So I think I don't want to promise to answer all the questions.
I do have some concerns about this. I mean, I think that indexing should be done. My concerns are, a couple of years ago, Betsy Ann Rask had an intern and who spent most of the summer doing it. And as far as I can tell, nothing happened with it. So it's been done.
Indexing this issue?
Yes, the indexing, and nothing really happened with it. And my other concern here is that Ameren does not have an intern, and she simply cannot take, this is a huge project.
Yeah, that is.
And she can't take it on this summer. I mean, it's as simple as that. Even though I think it should be done, but I'm concerned that it was done before.
Can we find out how far that intern went? I mean, Betsy Ann knowing Betsy Ann, she must have that report, that work somewhere.
Oh, it is there. It is there.
Is it work that can be built on?
Gail, did you want to weigh in?
Yes. So Betsy Ann, back in 2012-13, sent me the catalog. It's about a 200-page document, which I still have. And so it's the catalog all the way up to 2012. So there were, I'm not sure how many, dozens, maybe small dozens of new legislation introduced since then that would need to be added to it. But we do have the, all the way through to 2012 already in a catalog that I'm happy to send back to Ameren.
So we have legislation for the last 9 years, and that could be affected by this. How big a task is that?
Although I have to say that although there were statutes that were passed with the words physician and doctor in it, since that time, we have been able to catch a lot of bills that were introduced, and amend them in the legislature before they became law. So probably not many of those would need to be looked at and amended. It's really most of the bills up until 2012.
So can I make a suggestion? That the health community knows the bills that have been passed. Can the APRN and naturopathic associations take this on and do a review of the legislation that's been passed since 2013 or since 2012 where they, because you would know the bills that have been passed, is that, and then add that to the catalog, and then we'll see what happens with it.
I would defer to Travis and Sam for that.
Travis, do you want to let us know what you're capable of doing this summer?
Yeah,
What do you want to take on?
I'm willing to help.
Because I would say if it's that limited, then it might not be that much of a project, but I just know that over the summer and fall, Ameren is going to be overwhelmed, particularly with redistricting in the House, because she is the staff for that, and she's going to be spending most of her time this fall doing that.
The VANP can also undertake this, specifically looking at the terms physician, doctor, healthcare provider.
So then if that's the case, then I see no need to put it into this bill, because you'll just come back in January with a catalog that Betsy had and a supplement, just like our little white supplements that go in our green books. And then the appropriate committees and OPR and boards and Department of Health will begin to look at it and see where changes need to be made. Does that make sense, anybody? Senator Rahm?
I mean, I'm not going to disagree with that happening. People have sort of their own free will to bring us that information. We heard some discrepancies just today about the language in other states per how the Department of Health, interprets what happens in other states and how it was presented to us in committee. I still have concerns that this isn't just a matter of cataloging. These are major healthcare decisions. And so, I could see this being a question in the Health and Welfare Committee. I could see this being a conversation with the Department of Health, but I personally, and I'm new to this committee, but I just feel really inadequate with the time we have to allot to these issues to be talking about it as cataloging and not making pretty significant health related decisions.
Oh, I think you have to have the catalog first, because you have to know where it says physician that should also include naturopath, or should it just be MD, or should it include APRNs and PAs?
Right. So to me, should it include those things doesn't feel like cataloging. It feels like
but you have to have the cataloging first. That's the idea here, was to get the catalog, get it together, and then have the appropriate committees begin to deal with where the changes need to happen. This cataloging isn't making any decisions at all. It's just cataloging it and saying in Title 326A, Section 5, it says physician. What do we mean there? Do we mean just an MD? Do we mean a PA? Do we mean a naturopath? And then in the next section, it's the same thing. So the cataloging is just presenting the areas where attention needs to be paid. That's what the cataloging is.
Okay.
It isn't making any decisions or anything at all. We need to know where to put the attention, and some of it will be by the Department of Health. Some of it will be by the health committees, the standing committees. I'm sure there will be recommendations from different groups coming in saying this change should be made here, this change should not be made here. So, and that has happened, as Gail said, for some pieces of legislation that have been passed now. I think Ledge Council has become more attuned to making sure when they use the terms, what they mean. Is that true, Gail, that you would say that's?
Yes, definitely. Back in 2012, maybe a couple of years before, a couple of years after, we were coming in repeatedly to committees and asking that the language be changed. And during all of that testimony, there actually never was any opposition to it from anybody. It was
Right.
just really an oversight.
Yeah. Lauren?
I would just like to add that the scope of naturopathic physicians has shifted and changed quite a bit. And some of that has happened after 2012 as well.
So can we just assume that something will happen over the summer with a supplement to the catalog, and then the various committees will take it up? Health and welfare, the healthcare committee in the House, human services in the House, this committee, if it addresses a scope of practice for those that we have jurisdiction over, Vermont Medical Society, all those players.
So what I can do is work with the CRNAs and the NDs to expand the catalog to current time. And then we can go through it and sort of section it based on subject area and identify some of the statutes that we think ought to be amended just as a starting point. I know that there will be different opinions by different professions, but at least as a place where we can begin the discussion and then go from there.
Okay. Does that make sense, everybody? To do it that way instead of trying to put something in the bill?
Sure.
Yeah, I think it would be sort of begin to address, instead of just nickel and diming it and addressing it in little small ways here and there, we really would have a more comprehensive review, which I think is what Lauren has really been asking us to do. And I think we all would like to do it too, rather than fixing it per,
Yeah.
every time it comes up. But, and then so Lauren, your side will take on looking at all the other states, all the other practices and what they're able to do in what states.
So
Well,
Right?
I would ask
heard
that
you
if that's something that the committee would like us to do, then I'd ask that you put that request in the statute as a Chapter 57 review of scope.
Yeah.
Well,
You don't want that.
I almost hesitate to do that because there might be 300 places where the term needs to be changed. And I don't want Lauren to have to look at the scope of practice and the other states in 300 places. I think that's something that the health committee or the boards or whoever would do when they're making the changes in a specific instance. If you're only talking about the death certificates here, that's different, but I would put this all together.
That's what I thought we were talking about.
No, we are talking about, we've moved from death certificates to doing this expansive.
No, I understand that. And that we're going to build on what Gail and Betsy Ann's an intern did and what Gail has. And I got that, but I thought that Lauren was offering to do a statewide comparison, all states comparison of this practice and what's allowed in other states on death certificates. And maybe we would do it on one or two other issues that we had come up.
If I may, Madam Chair, I think it's a question of which dominoes fall first. Whether your committee assigns me a scope review on this narrow issue of the death certificates for NDs, and at the same time, Gail and her team does the updating of the index. So two dominoes at the same time. or whether we do the indexing and recognize the areas where there's statutory inconsistency. We engage with stakeholders, hopefully before the legislative session, to realize where there's friction around the proposed changes of the inconsistency. And then I think next session there would be, out of next session, I would think there would either be consensus and or committee and legislative consensus around what should be modified, or there would be at that point a series of scope reviews around, I mean, I can tell you just off the top of my head, we have a problem with compounding and administration versus dispensing, this is white bagging. We have the death certificate issue. I can think of several issues where this is going to come up and where you may want us to do analysis. And my preference would be to do it in a more comprehensive way once we understand where all the issues are and once we have the ability to start to really engage with stakeholders about where they are. It may be that the physicians don't have an opposition and we don't need to do a huge scope review on every issue that the catalog arises. It may be that the issue is not so controversial or is a little controversial, but the legislature just decides to act without the scope review, which is its right to do, or that it's really a proper scope review and we need to do it that way. So my preference would be to have the index updated and then some engagement with all the stakeholders around the index, hopefully before the legislative session, so that if and when I come before you, I'm able to say these are the areas where I think we have consensus and these are the areas where we don't. And this is where I recommend we do a scope. This is where I think you could act without a scope review, or this is where you can just modify the statute.
I agree with you. I think that it doesn't make any sense for you to start looking at just one area. I think that we need the cataloging first and then figuring out where, because you might come up with 6 different. Oh, I think you said 6. I wrote down 6. But anyway, I think that your second, so I don't think we need to put anything in here in this bill. And the same 5 of us will be on the committee next year because it's the second year. So we'll remind you all that we're going to do this.
I agree.
Okay. Dr. Rousseau, one last comment. You're muted.
Apologize. I agree with the cataloging effort. I think it's very important in regards to the issues of vital statistics. Until that time, it's, NDs are going to have to find another provider to sign death certificates, which isn't always easy, especially for the family of the deceased. So I look at it as a little more pressing public health matter. Secondly, in looking through the statutes, there's no place that I was able to clearly see that we're allowed to sign birth certificates as allowed by NDs who are practicing under the midwifery rules. There's no place in the rules that say that we could sign a birth certificate. And if the language that's in Title 26 is equitable for birth and death certificates, there's a discrepancy there because NDs are doing home birth deliveries, and there's no legal basis for them signing a birth certificate. So that would be one other reason why to possibly focus on this particular issue in this bill at this time.
I agree with you, and I'm sorry, but we have to have this bill out today because we are at the end of the session and this has to go back to the House because we've added a fair number of things here.
Yeah.
I simply think that we have to take Lauren's suggestion here and Gail's helpful suggestion and Travis's to work on this over the summer and to come back. And I am so really sorry that we couldn't solve this because I think it could be done, but I think that's where we are. Other committee members, do you want to weigh in?
I think that's where we are.
Ditto.
Yeah, I'm very open to moving forward on this next year, but I think it would be helpful to not do it in this piecemeal fashion and do it comprehensively. So we can look into both now, birth certificates and death certificates, after we do this catalog.
Senator Ram?
Yeah, I mean, I really would go back to feeling that I am sorry to the handful of families, it sounds like, who would like to have their naturopath sign the death certificate, but I think that's still outweighed by the concerns around making sure we're doing our due diligence on the safety and well-being and, proper death certificates and medical procedures for all Vermonters. I don't feel particularly compelled by that, unfortunately. I think this is an area where we have real due diligence to do before making a decision.
All right, so with that, we have draft 1.5. Amarin?
Thank you, Madam Chair. I just wanted to point out that in the amendment, we did change some of the effective dates, which was not something we've had a chance to mention. So before there's a motion, I just wanted to make sure that you were aware.
Good, thank you.
Would you like me to go through those now?
Yeah,
or
just
wait, okay.
tell us.
Okay, so originally, H289 as passed by the House had all provisions being effective on July 1st. With this amendment, this would change the effective date section, which would now be section 21. This is on page 28 of draft 1.5. You'll see that this act shall take effect on passage, except sections 2 to 7 and 13 to 17 shall take effect on July 1st, 2021. And that was in part to have the well drillers, and Lauren, please correct me if I'm wrong, there was a desire from OPR to have the well drillers section effective on passage. And then with these new additions, specifically the home health nurse related one, important to have that effective upon passage. And then also that new section that we went over this afternoon about applicants and licensees with criminal convictions. So those would all be effective on passage, and then the remainder of the bill would be July 1st, 2021.
Makes sense. Committee?
Good.
Okay, so does somebody want to move that we amend 289, 449 is in my head, 289 with draft, what is it?
1.5 or 5.1?
Yeah, 1.5. Anybody care to move that?
I would. Oh, Brian.
Okay, Brian?
Thank you, Madam Chair. You just took the words right out of my mouth. I move that the committee vote out H289 as amended by draft number 1.5.
Nope.
No?
We're not reporting it out yet. First, we have to amend it with 1.5.
Okay. I move the committee amend H289 with draft 1.5.
Thank you. Senator Ram, would you like to call the roll here?
Would. Senator Clarkson,
Yes.
Senator Collmore,
Yes.
Senator Polina,
Yes.
myself, Senator Ram, yes, Senator White.
Yes.
Passes.
Now.
Yeah.
Did you
Now,
have a,
I further move that the committee vote out H289 as amended.
Okay,
okay,
Senator Clarkson,
Yes.
Senator Collmore,
Yes.
Senator Polina,
Yes.
myself, Senator Ram, yes, Senator White.
yes.
And that passes.
Would anybody care to report this bill?
I'm holding myself in abeyance for the charters, which are forthcoming.
Okay.
Well, so fewer of them, and we'll see. We have.
I mean, I'm happy to do it if no one else will. We will still have the.
I'm happy to. Maybe, Madam Chair, I've done the OPR bill in the past. I'm always happy to do it.
Okay.
But maybe we could share it, and maybe we could divide it up and do, or I'm happy to do it. I have to say, I'm not mad for the brutal cage work. I quite honestly, I'm not very fond of that. And I'm not happy we're doing it, and yet I know we have to regulate it or it'll be worse. But I think it makes me uncomfortable. So that's the only reason I didn't volunteer to do it. I can hold my nose and do that, I suppose.
Why don't we put you down as the reporter, and then we can figure out if we should divide it up in any way.
Fine.
And if you do not want to do that section, we can find somebody else to do it, including myself.
I mean, I'd have a hard time doing it with a straight face, quite honestly.
Yeah.
Yeah, I feel the same way.
Yeah, I think Anthony and I are really have a problem. So I'm happy to do it all, but that section does give me
Okay.
I'm not happy with that section.
Why don't we sign you as the reporter, and if nobody else wants to do the MMA section, I will. Yes, Senator Rom?
I'm more than happy to do it. I mean, I just think the counterbalancing perspective is that, you know, martial arts have been around a long time. They might be modified in some way that's dangerous and inappropriate, but that's what we're trying to regulate. And Brazilian Jiu-Jitsu is used in police training. I mean, these are real martial arts. So I just don't want to call it a cage match.
I don't want to get into that conversation right now because we have a whole nother topic to take up. So what I'm going to do is I'm going to say Senator Clarkson will be the reporter. And if she feels uncomfortable reporting that section, somebody else will do it.
We'll get there. We'll see what we can come up with.
Okay. That's all we need to do right now. Okay. Sorry, I didn't mean to cut off the conversation, but we have a whole nother group of people.
We do. And I see the next group lined up at the bottom of the screen, ready to go.
Yes. Okay. So Senator Clarkson, you will send this up to the secretary. Okay, great.
Amron, would you just be kind enough to send to my email the last draft, the final, or do you need to get it edited first, or is it all done?
It has been edited. I just emailed you a clean version.
You are divine. Thank you, my dear.
Thank you, Amron.
You're welcome.
Thank you, Lauren, and I guess Gail and Dr. Rousseau has left, and Travis, thank you. And David Englander, thank you all.
Oh, thank you very much. And I just want to let you know that I've just received an email from the nurse practitioners that they are going to help in the effort, and I'll reach out to the nurse midwives as well.
Good. Thank you.
Thank you.
Thank you. Okay.
Thank you all for
Now,
your time.
committee, should we move on to our next topic, which is H435? And we've walked through that, and we've had some testimony. Where are we, committee? I've made some, I have a little list of suggestions here for myself, but I don't know where other people are.
Damien, is Damien coming? No.
I believe Damien might be double booked, so I'm here pinch hitting until he can arrive, since I'm also on this bill.
Why are we not surprised? Okay. So have we walked through? Yeah, we have. Yes. Okay. Now I'm just reminding myself because I know Jim Baker. I see Jim, and I see Steve, and I see Tim, who I don't remember. Okay. Great. And I can't remember where we left off last time.
I think we were having some conversations about it, and it was suggested that we had posted on our website the DRM study,
right?
And so if we want to, committee, to get ourselves back to where we were, and I have to apologize to everybody for putting this off so many times, but we are now done with retirement, and we can focus on this and get it done. So at this point, I think what I'm going to do is ask Commissioner Baker And anybody, if they have any comments they'd like to make before the committee starts making comments? Or do you want to have us start making our comments first and then react to them? What would you prefer?
Madam Chair, it's for the record, it's Jim Baker, the interim commissioner of corrections. I'm fine. I think I weighed in, last week when we talked. I know you do have Tim Doherty here, who is one of the authors of the Downs-Rachlin-Martin report.
Right.
Mhm.
And I think he certainly can provide some insight about the guidance that HCI took in creating the language in the bill, coming off the DRM report. I'll save my comments and I'll conserve time here.
Madam Chair, it would be great if we could do that. That would be wonderful.
Yeah. Yes, I was going to ask if we wanted to hear from Tim Doherty. And Jen, I believe, were you also a co-author?
I apologize, Jen. I didn't see you there. I didn't realize you were there. I'm sorry.
I just joined, no problem.
Senator Collmore, did you have a?
Yeah, I don't know how you want us to do this, Madam Chair, but I did spend an hour over the weekend reading the report, and I just made some quick notes. I don't know whether they'd be useful now or I can wait.
Why don't you throw them out now so that when they walk through the report, or not walk through the report, but give us the relevant information,
Sure.
they can address those at the same time.
So the report quite aptly discussed the issue of training. And I think there's no doubt that more is needed. And I don't think it's just necessarily frontline workers. I think even the folks that are in our institutions could be benefiting from being able to understand what they have for rights. And I'm not saying that isn't being done now, but I think if we had a little bit more emphasis on that, it wouldn't hurt. The report made a pretty good point of saying that once someone is released, there's very little that can be done in terms of supervision. Once someone is out in the community and are interacting with potential COs, there's only so much that can be done to prevent any sort of interaction. And I took that as a very good point. We talked last time about the drug testing and the polygraph situation. And I think Steve Howard made a pretty good point about saying that perhaps it should be expanded, not just for the COs, but for everybody that's in corrections potentially. The report also delved deeply into the retention and recruitment issue, which again, I think is a huge issue. We hear reports of people sleeping in their cars between shifts because they don't have time to drive home and get a decent 8 to 10 hours worth of sleep. The recruitment issue is a big one as well. This is not, in anyone's top 10 list of jobs to take. So it's hard to recruit good people to do this work. The report mentioned a mentor program, which I really thought was a great idea. I'm not sure there's anything in the legislation about that. I don't remember. And then they mentioned body cams, which I also thought was at least worth talking about. So those are the 7 pieces that I took away from the report. It's an excellent report. I will say that, again, it focuses only on one of our institutions. So what might be true in the situation that was studied doesn't necessarily mean it's true to the same exact extent in other places, but I think there's probably some commonality involved too. Thank you.
Thank you. Steve Howard, I saw you had your hand up.
Thank you, Madam Chair. I may have more to say after the report is presented, but just a little housekeeping request, which I hope the committee will entertain. We would love it if you would be willing to hear from correctional officers who work in this facility and other facilities after you hear the presentation of the report. I think it's important to hear from people who actually spend their time in the facilities to verify that the report actually reflects their experience.
Okay, thank you. And I think I think that our main concern around the report was around the drug testing and the sexual abuse that goes on. I think that that was mainly the concern of this bill. I mean, not the only concern of ours as legislators or people, but as reflected in this bill. So with that, I think I'll turn it over to Tim and Jen and let you do how you want here.
Tim, I'm happy to.
Wait, before you start here, I apologize. I'm so used to the same people being in our committee all the time that we didn't introduce ourselves, and I really apologize. I'm Jeanette White from Windham County, and I also sit on judiciary. So this is a topic I'm familiar with. So.
Hi, I'm Anthony Pauline. I represent Washington County.
Brian Collmore from Rutland County.
Allison Clarkson, Windsor County District.
Aisha Ram, Chittenden County.
Good, thank you. So, I'm sorry about that, but okay.
I'm happy to lead off with a brief explanation of the report. We can do this however is most efficient to the committee. We're happy to answer questions, and I could also give a summary of our recommendations, but understanding that this bill is fairly far along, I'd like to make it the most efficient use of your time as possible.
Yeah, I think that focusing on the drug testing section and on section 6, the sexual exploitation, and that would also drift over into sections 4 and 5, I think.
Yeah, but I'd appreciate just an overview too, and then going into those specific sections.
Okay, so I can start with a brief overview, and then I will address the drug testing specifically. So you who I don't know, I think there are some folks on here who I have met before. My name is Jennifer McDonald. I'm an attorney at Downs Radcliffe Martin. I was one of the authors of the report. My partner, Tim Doherty, who is on here with us as well, was another author. And then Tris Coffin, who many of you probably know, was led the report and was also an author, and regrets that he can't be here to join the committee today. My background is as a civil litigator in the state and federal courts, primarily commercial work, healthcare fraud, and then investigations and government enforcement. I want to recognize that the work this committee has done in bringing this bill together, which was, we were extremely happy to see this. The recommendations that we made, we stand behind. And we felt that many of those were captured in H435. So this was really important work, and we do appreciate your time. I want to go back. I think everybody may know the background of the work here, but this really started, I believe, in late December of 2019 with the report that was done by 7 Days. There was a lot that went into that report, so I certainly want to call out that investigation, which prompted the state to bring our team on to do an independent investigation to what was going on in Chittenden. I do want to address the comment about that this was certainly, the scope was to look just at Chittenden, but it's certainly accurate that there were things that we, within this investigation, that we could see that there was overlap in the other facilities, but our focus here really was specifically on the women's facility. Although, again, there would be a lot of overlap here, and many of the issues that we dealt with are not unique to the women's facility, specifically the staff to staff issues, which would have been consistent throughout. And then also, I think it's worth noting that although the specific sexual abuse issues that we looked at involved the women in this facility, those issues may not be solely, that they may be throughout the other facility. It's not simply just with women, and maybe male residents as well. So in order to do the investigation, we also retained we were the independent investigators, but we worked with the Moss Group, which many of you may know, and has a deep understanding of corrections. We went into the facility with the Moss Group and met with corrections officers and met with the residents through focus groups, and we coordinate that with Department of Corrections employees who were immensely helpful. We were met with cooperation throughout the entire time. I believe my partner spoke with Steve Howard. We had open dialogue throughout and would not have been able to prepare this report and complete the investigation without the cooperation that we received. And I want to commend everybody who was able to assist us with. These were complicated issues, and our findings were extremely troublesome. As you saw in the report, there were numerous instances of allegations, and as we've said, one instance would be intolerable, but the zero tolerance policy that we all want to adhere to, and which is required under the pre-allegation requirements, dictates that these are very, very serious things that we need to improve them. So that's a brief background of what we did in this investigation. It took place over a period of many months. We had hoped to complete it on a sooner time frame, but unfortunately, because of the pandemic, the investigation was delayed through challenges that no one could have anticipated. And I also want to point out that we all know what people who are living in the corrections system were experiencing during this time frame. And the fact that we were able to get in there at all when we were is really, again, commendable to the Department of Corrections staff. We wanted to make sure that anyone who wanted to communicate with the investigation had the opportunity to do so. We worked with other private investigators who were able to go into the facility in addition to the Moss Group and in addition to our contacts, were able to speak with people and have that open dialogue. And so we have endeavored in every respect to maintain the privacy of those who we spoke with. But again, I do want to emphasize that we had the opportunity to meet with many people on both sides, both residents and staff, and wanted to ensure that they had access to the investigation and to speak with not just the private investigators who we hired, but with our investigative team throughout that process. Specifically looking at there were two primary issues. Well, let me go back. So there's the substance abuse issue, and then there is the sexual harassment issue, and specifically on the drug testing, getting back to what we had initially, the initial question was, it was our, although there was not widespread evidence of drug use within the facility, there happened to be well-known situations in which residents and staff alike reported that individuals within the facility, staff in particular, were using illegal substances, and this was over the course of many years. And their feeling, both residents and staff, was that management wasn't taking these allegations seriously and or wasn't doing anything to address them. When we spoke with management, both former and current management, it was their position that they had done what they could to determine whether or not either substantiate or disprove these allegations, but with the tools that they had, were not able to do so. And the result was the findings were inconclusive. And so our recommendation for drug testing comes out of that, which is having a system where findings are inconclusive over a period of years creates the morale problems that were really frankly rampant throughout the facility and gets to the retention issues that were also addressed during this session. So really the most efficient way and from our perspective, the most fair way to reach a conclusive determination as to whether or not substance abuse was occurring in the facility was to have the ability to do the Yes, Senator Ram.
Yes.
I can wait till you're done with your sentence. I'm sorry. I was just trying to.
Yeah, I think it's probably best if we let them go through their presentation first and then ask questions, because I already have a list of them.
Okay.
And I'm sure everybody else does
Yep,
also.
getting in line. Yeah.
So yes, back to the urinalysis again, and this was something that when we spoke to people in the facility, they welcomed the opportunity because again, it was a tool that would be available to either substantiate or disprove allegations, and the benefit you can see on both sides. So if someone is accused of using illegal substances, because again, in the facility, rumors would, the rumors took on a life of their own, and they traveled throughout the facility and would occur over long periods of time. So the ability to disprove things is also a powerful tool, as is the ability to substantiate allegations of substance abuse. The particular one that we encountered was one that was well documented in the press coverage of this, and again, with that tool, would have been something that could have alleviated many of the morale issues in the facility. I don't want to get too off track. We've talked about, I think that I've covered what our conclusions were with respect to the drug testing. So I want to turn back to the community. Would you like us to go through each of our findings in the report, or would it be preferential for you to address questions to the specific issues that are in the bill in 435?
I think, committee, I don't know if you agree with this or not. I think it makes more sense for us to address questions as they relate to 435, because a lot of the recommendations don't directly relate to 435, and they will be taken up by justice oversight and judiciary, and probably House institutions and corrections. And so I think that it makes more sense for us to just ask the questions that we have as they relate to 435. Does that make sense to committee members? Okay, so I will lead off with a question here, and I guess I don't understand why we would need to do a whole study on whether or not we should be able to do drug testing in a facility or outside of a facility for DOC employees. If there were probable cause or reasonable suspicions, that could have already been done under our current law, is the way I understand it. So why would we not just use that and do the drug testing for those individuals who are suspected? And I don't know if that's for your study, or if that's a different question. So if it's a different question, then I'll hold that off until later.
I think that's that's a little outside the scope of our study. Our study,
Okay.
Whether or not on allegations of substance abuse that were brought to management, whether they could, based on those statements, and these would be statements from people who believed that they saw somebody using substances, and specifically the example that I referenced in the report was seeing powder, seeing suspicious of, but again, it wasn't to the extent of having found drugs in someone's locker or on their person. So these were more situations where someone believed that another person was using illegal substances. So whether or not under the current law that could happen, that was a little outside the scope of our report, but my understanding was that in the specific situations we looked at, they would not have been able to just require that person submit to a mandatory urinalysis.
Okay, all right, thank you. That answers my question, and I'll save it for a different time then. So Senator Rahm, I think you had.
Well, I mean, I suppose it's related. You know, you mentioned the press reports, and I was just rereading one of the articles where it says that 6 of the current and former guards reported someone suspected drug use to superiors, including to superintendents, but this person continued to climb the ranks. During a 2018 ceremony, Vermont Secretary of Human Services and Commissioner of Corrections named him shift supervisor of the year. So, you know, when I read that, it speaks to me to more than drug testing as an issue, but how the culture of accountability is created. I mean, that still seems very discretionary to me, what you do with someone's drug information. If 6 people are reporting that they believe someone's using drugs and that person's given shift supervisor of the year, I don't really see drug testing being the only piece of the puzzle to solve the culture of accountability issue.
Yeah, I think that's absolutely a fair analysis. It's not the only piece of the puzzle, but it is a tool. And in that specific instance, based on, you know, it was brought up over the course of several years. So these weren't all brought up at the exact same time period, which can add to the challenge. You have things that are brought up 1 month and then, and in this situation now, there were letters that were sent up the chain of command, but without the proof that they needed specifically on the substance abuse, actions on that end weren't taken. Now your question raises another point, which goes more to the HR component, which is a little bit beyond, not completely beyond the scope. But even without substantiations, what do you do, you know, given that these allegations exist? And that gets back to the fairness question of, if you can disprove something happened, that's also a very valuable tool, but if you can substantiate that is as well. So it's not the only piece, but it is an effective piece in the puzzle.
Senator Clarkson?
Yeah, Jen, we're having a hard time. You have a lot of background noise. Your sound is really a challenge. It's very it's hard to I don't know. I don't think I'm the only person having that.
It's very muffled.
It's muffled and you're not clear, and it's a lot of background noise.
Well,
is that better?
Yes.
Okay, I apologize. Feel free to raise your hand next time immediately and tell me to stop.
So Tim, did you?
Well, I was just going to say, and thank you to everyone on the committee for having us. And I just wanted to add, you know, just as a point of clarification, Secretary Smith retained us to do an investigation specifically focused on the questions of sexual abuse and harassment that were taking place at the facility.
Mm-hmm.
The drug issue was an issue that was, as we found out, and as was also made clear in some of the public reporting that was done prior to our retention, was sort of part and parcel of some of these allegations with respect to sexual abuse and sexual harassment. And just as a point of clarification, wanted to make sure that this committee understood that it was I wouldn't want to say tangential, but it was a related issue to the core issue that we were asked to look at. And one of the questions that Ms. McDonald and Mr. Coffin and I grappled with as we proceeded in our investigation was coming up with broad brushstroke suggestions for appropriate policymakers like yourselves to consider that would be pieces of solving the puzzle of accountability. And you know, drug testing was one of those pieces. It wasn't intended to be an end-all and be-all solution. You know, myself, before joining Ms. McDonald's law firm, I spent 10 years working for the United States Department of Justice, and I can just tell the senators, as a federal prosecutor, we were subject to mandatory random drug testing. So, you know, that was part of my professional cultural experience. And I think that the notion for the United States Department of Justice would have been, you know, you have people, federal law enforcement officials who are involved in making pivotal public safety decisions, and their impairment could obviously severely affect the quality of those decisions and have an effect on public safety. To be sure, senators, the amount of control that corrections officers have over women's lives in this facility is extraordinary. And given the amount of authority that they have, I think it's at least reasonable for policymakers like yourselves, with input from the VSEA and Mr. Howard and from Commissioner Baker, at least make an assessment as to whether or not that's an appropriate safeguard, given the incredible role and responsibility that these officers have over people's lives and over public safety issues writ large. But it wasn't meant to be a single magic bullet to solve all of these issues.
Thank you.
Can I just-
Senator Ram?
I just want to follow up. And again, I was having a little trouble hearing you, Jen, but I think I got most of it. You know, if I complained about a colleague and then they got shift supervisor of the year, and I knew others were making those complaints too, I would still worry about what it means to file that report, let alone substantiate it with evidence like drug testing. So I think my larger concern is that drug testing might substantiate a report, but how comfortable do people feel reporting and not feeling like they might be retaliated against if this was the situation before? You might say the buck stops with a commissioner, and Commissioner Baker seems great, but there's a whole chain of command where there's a lot of discretion for management to make decisions about what accountability looks like. And I feel like that's a gap right now in the conversation. And I can't talk about just substantiating through drug tests without talking about how you even put something forward and feel confident that management will hear your concern and work to substantiate it.
And that's a significant problem that we encountered. And looking at H435, you know, we were really pleased to see the Department of Corrections Investigative Unit proposal. And again, these are all pieces of the puzzle because there are numerous components. So you speak to the retaliation or whether or not it will go anywhere. And there were certainly reports that we encountered from within where people had made complaints and did not feel like they were being addressed. The complicated picture here involves there are situations where reports were being made and did follow through the framework that was set forth in how things are supposed to be investigated. There is a lack of transparency, in part because in certain situations, people are entitled to some privacy, and this goes to the human resources protections when complaints are made. So the whole picture needs to be looked at. It's not, as Mr. Doherty suggested, one magic solution, but you're right that when complaints are made, they should be taken seriously. And that also goes to, it goes up to not only of the investigation, and again, we think that the Corrections Investigative Unit does address some of the issues that were here with it going to Department of HR Investigative Unit, where maybe not everyone involved in that investigation had experience in corrections that would help inform the investigative process, but also that once those conclusions are reached, that whatever is determined, that it actually reflects what happened. So I can think of one situation, and this is in the report, where someone reported being sexually harassed by a superior. And the result was, after the investigation, some of it was substantiated, some of it was not, was that the individual superior ended up, I believe, getting 2-day suspension and then 3 hours of sexual harassment training, but still remained a supervisor of this particular CO. So those are the types of things that also need to be addressed. And again, I think a lot of what is in H435 does go a long way to addressing those issues. But again, it's the whole picture in the facility.
Senator Clarkson.
So I'd sort of like to go back to Tim's and forgive me, I've only read the recommendations and somebody I haven't had time to read the whole report, and I apologize both to Sarah Coffey and to you too. But
we worked so hard on it, Senator.
I know, and I'm looking forward to reading it, and I apologize. I just give us more time. The interplay between the and it goes to morale and on both sides of the bars, because the interplay of sexual of substance abuse and use of substances for sexual favors and as a currency within the facility, to me, that that also undermines morale of people, both from the residents' point of view and from the staff. And I'm just curious how much that, what you're recommending to get at that challenge of using substances as a currency for sexual favors.
Well, I would say, Senator, you know, you're absolutely correct. And I don't think anyone on this committee, nor Mr. Howard, nor Mr. Baker, would dispute. In fact, I think it's on dispute that substance abuse is a significant, plays a significant role in the lives of a significant number of the women who live in the facility right now. And as a result of that demographic, socioeconomic, and public health issue, the residents of the facility are vulnerable to predation based upon that history and that situation. And that does create the potential for a toxic mix, absent appropriate safeguards. And, you know, I think that, you know, again, one of the reasons why we thought you should consider mandatory drug testing of some variety was that issue. But that's also one of the reasons why we made some of these other recommendations. Like, for example, and H435 addresses this, a commission of appropriate folks with appropriate backgrounds who can stand somewhat outside the system, but can add some both sunshine, some guidance, and credibility to the process that's in place. Because once, and I think Senator Rahm touched upon this as well, once that credibility is undermined, it is really hard to regain. And, you know, Mr. Howard introduced this discussion by urging this committee to hear from some of the corrections officers who work at CRCF. And I just want to put in a plug for that. There are a lot of tremendously dedicated folks, from, you know, entry-level COs to very senior people who are working at CRCF right now. And I was the DRM person who was in the facility this summer. And one, we couldn't have done this investigation without their cooperation, which was scary. And as I'm sure you can all imagine, difficult to have strange lawyers come into your workplace and ask you all sorts of nosy questions. But it was also very inspiring. And one of the things that we heard from a lot of folks at all levels within the facility is that they wanted accountability. They wanted to feel like when they spoke up about a colleague, for example, there was a process in place that would not only protect them, but that would get the job done, because they wanted to do a good job. They wanted to do well for the women in the facilities. And that was one of the terrible parts of the story that, you know, that Senator Rahm articulated, is that this wasn't a blue wall of silence by corrections officers and VSEA employees. This, you know, that there were people in the facility who were speaking up, who were not getting the satisfaction that they wanted. And so, you know, I think that having a commission like that's been proposed would allow a degree of accountability and a degree of sunshine into this, at least for a short period of time. And I see that it has a sunset provision. And if it doesn't work, you folks can get rid of it. But I think it would lend a lot. I think it would lend a lot, in my view.
Yeah, thank you.
So, committee, what I'm going to suggest, I think, is that we start looking at the bill itself. And I have some suggestions, and I'm not exactly sure the best way to do this, but I will throw out my suggestion on each section, and then we can, other people can throw out their suggestions if they want to. I spent a lot of time with this bill this weekend, trying to figure out what I really thought about it. So does that make sense, committee? And then is to just start going through the bill?
Well, are
Senator
Tim,
Clarkson?
are Tim and Jen going to stay with us? Because I would, I guess before, if they're going to depart or if they're going to stay with us and go through it, because I'd love to hear from them about, sort of what their top, their top hopes for this bill and what they feel the strongest about in it as well.
Okay, I don't know what your schedule is here. Do you intend to stay with us, or do you have other pressing things that how you have to get to? Because we understand how busy you are. And would you like to respond to Senator Clarkson first, or stay with us? Or both?
Well, I can't speak for Ms. McDonald, and she surely won't let me. But I think generally speaking, we view this as part of our engagement that the state gave us the responsibility and, quite frankly, the privilege to work on. And we're really here at your disposal. If you'd like to say goodbye to us, we will leave you to your important work. And if we can be of use, I think we can stay on.
I suspect that if you are willing to stay on, that would be helpful as we go through it. Does that make? And anytime you feel you have to leave, we understand that, but it would be helpful to have your comments as we go through it. And in kind of the way it just makes sense to me to look at it section by section. Is the committee agree with that? Are you okay with that to start?
Yeah.
Okay, so section 1, and I think this is going to be a very controversial suggestion and probably not well taken. But the Justice Oversight Committee has said that they simply do not have the time or the resources to do this summer. They've already told me that. So my suggestion is that rather than is just to take this out and to ask DOC to come back next year with some suggestions, some specific suggestions about where and when and how they should do polygraph testing, and suggestions for how they should be allowed to administer drug testing. That's my suggestion. So any responses? I see Senator Clarkson has her hand up and Senator Polina has unmuted himself.
Oh, well.
And so has Commissioner Baker. So I'll jump to Senator Clarkson first.
I'm not sure giving the Department of Corrections this is the right, I mean, I think it should be an objective group looking at it, not necessarily the group that are being asked to actually have the polygraphs administered to them. And I think it doesn't make much, I mean, I'm sure they would do a fine job, Commissioner, I'm sure, but I would feel much more comfortable having an independent group looking at this with maybe a representative from DOC, but I don't see this being done internally. I mean, it would be too, I mean, not, I hesitate to say self-interested in the results, but I mean, they may not want polygraph testing, and it sounds like a lot of them don't. So why would you, it strikes me we need an objective group that would, are a little more independent.
Fair enough. Senator Polina, I saw you unmuted yourself.
I think the polygraph testing is pretty controversial in itself, to tell you the truth. And so there's a whole question of how appropriate it is, and which I guess is part of what this study was supposed to look at. My first reaction was to say, yes, let the corrections department come back with some recommendations that we can debate next year. But I also wonder, depending on whether we're going to recommend going forward with this corrections monitoring commission or not, which is a question we'll deal with in a couple of minutes. I mean, that could be a task for this corrections monitoring commission, should we decide to put such a thing together.
That's a great idea.
Senator Rahm?
I tend to agree with Senator Polina. I'm trying to make sure I understand who the stakeholders are in all these different groups. I was just sort of refreshing myself on the current thinking around the efficacy of polygraph tests. You know, I know we don't have time to delve into that, but I think, you know, I would want a group to weigh in on this. I just, you know, don't really want us to be spending all our time on polygraph tests as opposed to things that might actually help change the culture of accountability. I think it's a little bit of a red herring, polygraph tests. Right?
I just want to complete that thought, because I think it is sort of a distraction from the real issues. I mean, one thing we haven't talked about, and I'm not, at some point we will, is how you change the climate in the workplace there. You know, do people likely to take drugs go for a job in the corrections department, or do people end up in the corrections department as staff and then decide that they're going to take drugs? I mean, which comes first, the chicken or the egg kind of thing? So I just wonder whether the study that people did, whether they actually talked to the workers there about how they felt about working there, not so much about how they felt about taking drugs, but you know, what about the stress at the workplace, that kind of stuff. And if you're not sure whether you can report misbehavior, I mean, that undermines your ability to do your job. So I just think there's a whole lot of human stuff going on here that a polygraph test is not going to necessarily solve. I'm not saying I'm 100% opposed to polygraphs, but I don't see them as a solution to anything, but I could be missing something totally.
So Commissioner Baker, I saw you unmuted yourself.
Thank you, Senator. As a reminder, both the polygraph and the drug testing is major policy changes, right? And I'm not speaking for the members of the House Corrections Institutions. We're supportive of polygraphs, but just to be clear, we're not talking about polygraphing current employees. We're talking about polygraphing as part of a hiring process. And you know, where does this come into play? It comes into the quality of the candidates we're getting. And I agree. I've been around pre-employment polygraphs for 45 years. They're not an end all. They're a tool that's in a bigger package. We have significantly changed our hiring process. The class that we're putting in a week from yesterday will be the first class where we've conducted background investigations. And so where does this play into? It plays into the quality of the candidate you're getting. And this plays into conversation that was going on that I was listening to. And I think Senator Collins hit this, is that this is a very difficult job. You don't have people like for the jobs. This is very difficult. Although we do a very good job with our two recruiters hiring, we don't necessarily have a problem hiring. We have a problem retaining.
Yeah.
And some of that is some of the quality of the candidates we get should have never made it through the process. So again, the polygraph is focused on pre-employment.
Got it.
A bigger package. I actually like the suggestion that if you were to move and support the creation of a commission, and I don't want to get ahead of myself, but I'm a huge supporter of creating a commission. And I think Tim Doherty said this, bringing sunshine into this process. I can go on and on about accountability culture. After being here 15, 16 months, I have a pretty good idea of how corrections got to where it is. And we're working every day on these issues. But We need to open up the curtains and let people look inside our operation and see exactly what's going on inside the organization to bring sunshine to it that brings accountability. So I don't think it's a bad idea thinking about having the commission take a look at this as something they look at. I would not support us coming back with suggestions to you because that doesn't bring the stakeholders to the table that should come to the table around polygraph and drug testing. Drug testing, I know you're going to get to that in a minute. Senator White, I heard you say you believe the law allows us to do it now. I do think that we have issues around contractual relationships with our employees that have to be addressed. Just because it's illegal doesn't mean that it's allowed under a contract. And I'm going to sound like Steve Howard now. Respecting the rights of the employees under their bargaining rights. So I do support the idea of taking a look and studying what's the best way to approach drug testing, if in fact it's a good idea. But there were conversations here. Drugs inside our facilities compromise the safety of our employees and the individuals that we have in our custody. I can't emphasize that enough. The diversion of drugs that go on inside our facilities, we have made major drug seizures over the last 6 months in our facilities. It compromises the safety for everybody. And I'm not saying employees are doing this, not what I'm saying. But to go back to the point that was made about the stress, there is issues around overuse of alcohol and stress-related behaviors that directly impact the quality of the life for the employees that work here. And so I would ask not just to write drug testing off, have us come back with recommendations. It's got to be, I think, a very broad study done by individuals that are stakeholders at the table to come back to recommend how that can best be done. So those are my comments on those 2 points.
Thank you. Senator Collmore, I saw you had your hand up.
I actually was going to invite the commissioner to speak because he's been very patient with us up until we asked him to weigh in. So I knew he had something significant to add, and it's a thorny issue. There's no doubt. I don't know what the capacity of DOC is even to do the testing, let alone another agency. It's that would be a pretty substantial job, I would think.
Senator, I don't want to overemphasize the drug testing either. It's not like we're going to. I just think it was put in as a result of the allegations that were talked about in the report. And I'm not saying employees are using drugs. I'm not saying that at all. But I do know in at least one case that Tim Doherty or Ms. McDonald may have referenced about a prior incident about drug use. Prior to me getting here, I've read that report, that internal report. And again, I don't think it's widespread. I just think we have to study it and make sure this is a major policy decision that's being made. And I would not start a drug testing policy, even if I thought it was legal, without making sure the stakeholders had a say in what that would look like.
Oh, I do agree with you. I still don't quite get why, if the separating the polygraph and the drug testing here for those two, if the department feels like it's an important pre-hire issue, why you can't just come back and say, these are the positions we'd like to be able to administer polygraphs to before we hire them. I mean, it's not, it seems to me it doesn't need a study to just decide which positions you might recommend doing on, since it's pre-hire. It's, I don't see why I'll separate that from the drug issue, but the polygraphs, if you came in and said, we'd like to do a polygraph test on everybody or on this level of employee and up, or just management, or just people who work in the facility, then those are recommendations from you because you're the ones that know how your hiring process. So,
I can answer that, Senators, because right now it's illegal for us to do it.
right, I know.
So in order for us to do that, that's what the bill started out in House Correction Institutions, and they moved to a study committee. So in order for us to do it, there has to be a statute change.
Oh, right, I agree with that, but my point was, why couldn't you come back to us in January and say, these are the positions and we'd like to do it for on pre-hire, and then we can make the statute change. I don't know why it requires a study to come back with that, but Senator Rahm, and then I see Steve Howard has his hand up.
Well, maybe it's worth asking Representative Coffey on the House side if they spent considerable time on why polygraph tests came up as such an important component of this. But I'm reading a lot from the National Academy of Science, from the ACLU, from others that say polygraph tests are inaccurate. They're banned in most private settings. They are disproportionately, find Black people guilty of lying. Like, unless we hear something compelling about polygraph tests, I would actually propose taking that section out.
Steve?
Thank you, Madam Chair. I think I just want to just a few quick comments, and I'll reiterate, I think, my testimony from earlier from last week. I don't think VSEA has, despite, I think there are some concerns consistent with what Senator Rahm just raised. We do not have concerns about polygraphs pre-hiring. Our major focus is on having a standard for drug testing that is more aggressive than what we would ask law enforcement in the Vermont State Police to have, who carry a weapon and have the ultimate power of life and death, which our correctional officers do not have. And so we would say that probable cause or reasonable suspicion, and in the case in the article, which still has not been proven, just for the record, 6 complaints would seem to have reached one of those standards. So the question is, why did management fail to fulfill its responsibility there? Our concern, I think the only concern we would have with Senator Polina's proposal is, and it's a general concern about the management culture of the department, which is all of these outside forces that come in to decide how the department should operate, that are completely disconnected from the people who are actually on the ground in the field and in the facilities operating them. And that's not just, the University of Ohio or the folks in Waterbury. It's just all of these folks from outside who are coming in to tell the people who are there for 12 hours a shift how and what should be done. So the only concern we would have is if you did go to the commission, there's only one retired correctional officer on that commission. And we would strongly encourage some mechanism to multiply the number of current correctional officers who would participate in the development of that policy. You can't get buy-in on a policy in the Department of Corrections if it comes down from on high and drops into a facility, which is what happens now almost all the time. You have to include the people on the ground who are running it. So I guess that would be our only concern with Senator Polina's suggestion, is that there would not be enough participation by folks who are actually in the field or on the ground in real time.
Okay, so Senator Polina.
I would just quickly say that I did, after proposing what I proposed, I have been taking a hard look at the commission, and I do think we need to reconfigure the commission should we go in that direction.
Okay, I'm going to
Senator White, Sarah.
I do see that.
Okay.
Yes.
I'm sorry that my camera's off. I got my COVID shot yesterday and I'm kind of like feeling pretty terrible, but I just wanted to respond to Senator Ram's question.
Okay. Okay.
We lost you, Sarah.
I think the way that our committee thought the National Investigations Unit. Okay. Okay.
You're going in and out.
Okay. I would just say the drug testing we felt needed further study in some way because we felt there wasn't enough time. So I'll end there since I'm
Did you
going
take considerable testimony on polygraph testing?
No, we didn't. We didn't. And my my feeling that my personal feeling is that I questioned whether that needed to be in there, but some folks wanted to just have the opportunity to explore what that would look like, you know, because we saw that this is really complicated when it comes to negotiations with state employees, and we just saw it really was complicated. So, and I think you do have a decision in front of you, since the Joint Justice Oversight Committee said they don't have the bandwidth for that, to look at that. But I'm hoping that you can look at in terms of the commission, you know, we wanted people on there who had experience in and around corrections, but who were not.
We keep losing you, Sarah.
I'll just end there.
Okay. So yes, Senator Clarkson.
No, I was just trying to, we lost you at the beginning of your explanation, Sarah, about who you wanted on the commission and why you chose the people you did.
I think she just said she was signing off. She really is very sick.
Oh no, I'm still here. I think
Okay.
I think we wanted to have a well-rounded, you know, we wanted a judge, we wanted a former judge, we wanted people who had experience with corrections, we wanted a former corrections officers. I think we wanted, you know, people who would be most impacted. We wanted formerly incarcerated women, the Vermont Network for Sexual and Domestic Violence represented from there. So we wanted it to be well-rounded. I'm sure there can be improvements there, but that's, you know, we felt pretty good. We felt that it really needed to be an independent commission.
Right. Thank you.
So I'm going to make a suggestion that we move, since we've kind of started crossing over into the commission here, that we move there and then we look at who they are and what they should be doing. And so my comments on the commission were on page 5 in number 2, that we remove the line that says it may be employed by the Department of Corrections or work in any part of the state correctional system, and that we remove that work in any part of the state correctional system. Because in my mind, the state correctional system, the way it was defined to us, it included the community justice centers, restorative justice, all of those. And I think that if we're going to have a commission, that those people should be involved in it, because they're a real part of the criminal justice and corrections system. So they see the impacts of what happens to people when they're in the system. So that I would also add an H and a J, I think. This brought up to us from Steve Howard that there are right now plenty. Oh no, I'm going to the powers and duties, but under the powers and duties, I would add a G and an H. One of the things that Steve Howard brought up to us, that there are currently plenty of policies and procedures in place, but they often aren't enforced or followed. And that I would put in there that this commission needs to do a review of the current policies and procedures that exist, and whether they are enforced and how how appropriate those policies and procedures are and whether or not they're enforced, and if not, why. I would add that. And then I would also add an H that says review the staffing needs. That's my suggestion for section 2.
So this is the, oh, I just lost the name because of
This is
Department
the
of Corrections
monitoring
Monitoring
commission. Yeah.
So are we, I think it's a very well-rounded group of people, and perhaps we could take some of the ideas for what accountability or hiring look like from the first section and give them part of that as their charge. I'm still stuck on section 1, I think. Like, do we even like that section? And should we take some of the ideas in there and just give it to this monitoring commission?
I actually don't like the ideas in section 1.
Me
I
either.
think,
Okay.
I think corrections can come back and say, these are the positions that we would like to do polygraph tests for pre-hiring. I don't think that requires a study.
Yeah.
And I think the drug testing part, I would, I have mixed feelings about it because if you're going to do anything, it takes more study, but I'm not sure that I can think that we should go with anything more than probable cause or reasonable suspicion to do a drug test on a corrections employee any more than we do on any other employee in the state. I just, as Steve Howard pointed out, cops have guns and they don't have random tests. You have to have probable cause or reasonable suspicion to do a drug test on anybody. We have people working in institutions, the state psychiatric hospital. We have people working in institutions or group settings for kids. And so I have real problems with us focusing a different drug testing standard on corrections employees. So there's my thoughts.
So you're suggesting, Jeanette, to add that to the powers and duties of the commission? Because I support the commission. I think the commission is a great idea, and I think it is well-rounded. I think it's a thoughtful group of people they've considered putting on it. So you would add 2 additional powers and duties, Jeanette? Is that what I hear you're suggesting?
Not 2. I wouldn't add the polygraph. I would just take that out completely. And the drug testing one, if we wanted to put in there, I would say that it had to be something like, the 2 that I mentioned.
Yes.
Right,
Yes,
yeah.
the 2 that I mentioned. And then if we wanted to do drug testing, I would say something like that they needed to work with VSEA to make sure that
to develop
there was the ability to do probable cause and reasonable suspicion as part of the contract, that if that's as far as I would go.
Right. Well, or they could develop it with in cooperation or whatever with the VSEA, develop a drug testing policy. I mean, you don't need to prescribe it too much, but let them do it in conjunction with the VSEA. Let the commission recommend a drug testing policy.
I think that we just need to be very clear that it can't be a more stringent drug testing policy than the rest of the population that is imposed on the rest of the population.
There is no, but there are other drug testing. I mean, I'm not even clear on what the drug testing requirements are for other parts of state government.
Our state law says you can only do random drug testing if, I think Steve knows this, if you have reasonable cause or reasonable suspicion or probable cause. You cannot do,
Damien's here to help us.
Yeah.
Probable cause and reasonable suspicion.
No, It is
No.
not reasonable suspicion, it is probable cause. Reasonable suspicion is a lower standard. Probable cause. I'm sorry.
Yeah.
My microphone was in the wrong place.
Yeah, I was.
Thank you. So yeah, it is a probable cause standard for state government. You have to have probable cause that someone is under the influence of the drug at work or is using the drug at work. So this isn't probable cause to believe that they might have used the drug over the weekend. It's probable cause to believe they're under the influence or using it at work. Reasonable suspicion is a lower standard. And you also cannot do random drug testing. It has to be related to a specific event that gives you that probable cause.
Yeah, I guess I realized that. And I would like that to remain the standard, I guess. And I don't know how else to say it.
Well, I think you just said it, but my concern is that if you had other departments where this was raised as a major concern and a problem, maybe you'd feel differently about it. When you have a department where it's been raised as a serious issue, even if it was, well, I feel comfortable letting the commission work on this with the VSEA. I think that would be, I think that would be great, and to recommend a policy back to us. But I do think that not all departments in state government, like we don't get these complaints about tax. We get these complaints about this particular department. We get these complaints in very specific areas. So, I think that what we're trying to do is build morale, improve retention, recruit more wonderful people. And if this is at its core a piece of our challenge, I think it needs to be addressed, even if it's short term. But obviously we want to do it within the confines of what we've allowed for state employees.
I'm not sure that it is a core of our problem. I'm not convinced of that. How many employees are there in the Department of Corrections?
Thousands.
Does anybody know?
I can give you a rough number, Senator. We're around 1,085.
1,085. And we've had how many complaints that have been substantiated?
Since I've been commissioner? None.
And how many complaints that have been unsubstantiated?
You may not actually know that. Is that actually a known?
I don't know.
There have been several incidents where there has been talk of drug use, but not substantiated.
So it seems to me that if you have 1,000 employees and you haven't had a substantiation in a year and a half, that maybe it isn't a core of the problem. So
I only meant it was one of the problems that have been identified as needing. I mean, morale. I mean, there are hosts of other ones. Obviously, it's just.
Anybody else have any thoughts on this?
On what?
On the drug testing. Is what if we should put it in here, and if we should put it in as part of the commissions, what should it be? Yes.
Okay. No, go ahead.
I feel like now I'm struggling to remember like the yes or no answer to your question from before, Madam Chair, about it. If they had 6 reports that somebody was suspected of using drugs in the facility, did they have the power at the time to randomly drug test that person and use that to substantiate those claims? And they just didn't.
And I don't know that it would be a random test. It would have to, I don't know how that works. Steve, do you know?
Sure, yes. So, sorry, I'm trying to figure out whether I'm muted or not muted.
You're fine.
So yes, the law is very clear. There is a state law that governs this, and they would have to have probable cause, which that is the same standard that with some exception for federal positions where a federal law requires a drug test. They could, if they had probable cause for a specific incident, they could administer a drug test. I think one of the things that's really important here is that throughout the report and in the testimony before the House Committee, directly from COs who work in the facilities, drug use by COs is not seen as a widespread problem. It is not seen as a widespread problem. The hiring crisis, the staffing crisis, the management crisis, 7 superintendents in 9 years, which is a problem pervasively throughout the system, the churn of superintendents. Those are the major issues,
right?
Which I would love to see the commission also address. Why are the superintendents, why do they turn over so rapidly? What happens to them when they turn over? Where do they go?
Yeah, I agree. I think we should add all sorts of things for the commission to review. Yeah. But I think your language, Jeanette, was good about adding the drug testing, working with the VSEA on that and coming back with a recommendation. I mean, we have probable cause. Why, after 6 complaints wasn't probable cause pulled out as, I mean, what's the threshold that why wasn't probable cause used there?
And I think Commissioner Baker, the reason I mentioned VSEA is because I think Commissioner Baker said that it might be a contract issue. They might have to work something out with the contract, and that's why if it could be worked out with VSEA, and I can't imagine that if that VSEA would not agree to allow testing on someone if there was probable cause. So that's why I mentioned VSEA, is because of Commissioner Baker's comment about the contract. Commissioner Baker, I saw you.
Yeah, I just look. If you're going to put in a policy of drug testing, you got to follow the state law, and I certainly wouldn't do that as commissioner unless I had a conversation with VSEA about how that was going to go.
Right.
It's just
right.
Yes, the law does allow you to do that, but again, I think Steve would agree. If he found out that I had done 5 drug tests in the last month, I'd certainly be hearing from him. So this is a respect of the workers' rights to make sure they're protected, and I think you have to have a conversation about it. I agree that since I've been here, 16 months, I don't see the drug issue as a real issue. The other thing I would caution people about is, and I can't go into it in public because these are personnel investigations, but I'd be very careful about, what you may have seen in a newspaper article about how many times somebody was reported. I would be careful about that as the guide, as the asking the question, why wasn't a drug test done? And I can't answer that because I wasn't here.
So Ameren, yes, Senator Polina.
I thought you had said that the question was whether the working with VSEA and the commissioner, they should come back with a suggestion. I would be more likely to say, should there be any changes to a drug testing policy? Because that might be a simple no answer.
Oh. So that was a suggestion that VSEA and the commissioner come back. And the other suggestion was that it be put in here in the commission's responsibility. Senator Colomar.
This is on a completely different topic, Madam Chair, if that's okay. If it isn't, I'll just mute.
Go for it.
Somebody help me out, please, and tell me why in the composition, and I agree with you, Madam Chair, about changing that a little bit. Why are we so focused on people that are either former or retired or that sort of thing? I would see a great benefit in having at least one person who's currently involved in the system, at least be able to me, and it's, how I am with analogies, it's kind of like on an assembly line, making an automobile, having someone in the office 3 floors up make the decision for people that are on the floor. And I'm not saying it's got to all be that way, but to me, it would make some sense to have someone that's actually on the assembly line say, hey, did you ever consider this? Or what about this? Or that sort of thing. So I'm just going through the composition again. You know, a formerly incarcerated individual, a former corrections officer, retired attorney, a former judge. Why can't there be, and I agree with you, to strike out that number 2 in its entirety. And I see some benefit in having someone that's actually working there right now, at least be able to give some sort of input.
I actually think you're right. And it's interesting because when I looked at this, when Representative Coffey was talking to us about about the makeup of it, and I started thinking, we're talking particularly about the corrections. We're talking about corrections here. And yet there are 7 members on the committee, and only 3 of them have really intimate knowledge of corrections. The others have intimate knowledge of the criminal justice system, but a former judge with knowledge of the criminal justice system may never have been inside a corrections facility or may not know anybody who works in one. I mean, I just have some questions about the makeup of the board, as do you, Senator Collmore. Does anybody want to comment on that?
I share those concerns. I share those concerns. I think that we need people who are on the ground doing the work. I would say one other thing about the commission, or 2 things really. Later on, it says that they should, I forget the wording exactly, but they should work to make sure that the commission is diverse. The appointed entity shall appoint members that will create a diverse commission, including gender, racial, and cultural diversity. I mean, there's no guarantee that's going to turn out to be the case, though. They should do their best to create a diverse commission. If my understanding is that there's a large percentage of people in our prison system are people of color, I mean, I think we should be clear about needing that kind of representation on the commission as well. I also think we should talk about adding some in their powers and duties. One of the things they should look at, I'm just saying this in a general way, they should be looking at working conditions in the correctional system as well. We could refine that language, but something along those lines.
Yeah, I added staffing needs, but I think working conditions also. And I would actually add geographic diversity also in that, because I don't know, but Senator Collmore suggested striking out the whole of section 2. I just would strike out that part about nobody being currently involved in the corrections system. But Senator Romp, I think I saw your hand, and then I think I saw Commissioner's hand.
I don't know if my hand was up, but I definitely agree with what Senator Polina said, to the extent as well that I think we would be, I think it would be misguided of us to just focus on assault in women's prisons. I believe there's probably a lot of assault, and maybe it's been taken up by the committee before, in men's prisons as well. It just hasn't been the subject of this kind of public expose, and it's probably harder to talk about. And I think it would be good to have either current people incarcerated, but at least make sure that there's a couple different facilities represented as well. I think we need at least 2 current or formerly incarcerated folks, but I think there is a gender discussion that's important as well here, about it being hard to talk about male sexual assault, but that's probably occurring at high rates as well.
You're right. I think you're right. Commissioner Baker, I saw you.
Yeah, a lot of conversation there, so I'm trying to catch up with it here, Madam Chair.
So are we.
Yeah, I would not support a current member of the staff. This is not, there's labor management meetings, we interact with the union. This is not meant to, this is meant to represent other voices. And I appreciate the fact of what I'm hearing, both from Steve Howard and from Senator Collmore. I understand that. There are other ways of hearing that voice. I think for me, where I sit as the commissioner, the pressure that's on me from the advocacy community and other special interest groups around the way things have unfolded inside corrections is meant to give them a look inside the system. That was the idea of the commission. Fashioned after the State Police Advisory Commission, I have absolutely no problem with the diversity issue. The only thing I'm going to caution you is every time I hear you add, geographic or finding people to serve on these commissions are not easy, right? I mean, it's not. That's why I think, I know that, of course, Representative Coffey is not feeling well and she dropped off, but I think it was part of the conversation that happened inside House Corrections and Institutions was about not getting this too big. It's not meant to be substitute for the commissioner running the Department of Corrections.
Right.
It's to bring sunlight into the organization. One of the problems that I believe is a problem with corrections, one of many, many problems, is that it's just the constant mistrust, suspicion about what goes on inside corrections. And corrections hasn't done a good job over the years. When they get attacked, they tend to go insular. When they go insular, they become less transparent. It's one of the things that I've tried to work on for the last year. And part of the idea behind this is to open up the organization for people to take a peek inside from the outside, to build that trust. And it is important to have ex-incarcerated individuals participate. Certainly if there's a second person, and Senator Rahm, you're 100% right. Sometimes in these conversations, because this was focused on the women's institution, we lose track of how many males we have incarcerated. We lose track of the transgender community. We lose track of a lot of folks in the process. The idea of the diversity on this group was to have people familiar with the criminal justice system, that we could open up the transparency of the organization. I'm not trying to cut out, I'm sure Steve has a different opinion, but I'm not trying to cut out a working member of the organization. The other thing I would caution you about along those lines, what I envision this commission doing is the commissioner justifying to outside ears what he or she is doing when it comes to discipline, and briefing them. And I go back to my days as the police chief in Rutland. I answered to a Rutland Police Commission. And when I was the colonel of the state police, I answered to the State Police Advisory Commission. I briefed them on a monthly basis on the internal affair cases. And let me tell you, if you had somebody come up for the third time in 3 months on a case on internal affairs, the questions were asked of you as the chief, as the colonel of the state police, what are you doing about this? That's the idea behind this. So if you've got a member of the union on that, it's going to limit the conversation about this. So I would just ask you to think about the bigger picture here of what this commission is all about. It's about bringing accountability and transparency inside corrections. So I don't know if that helps the conversation or not, Madam Chair.
Actually, it helps me because I just reread and it isn't going to come up with any policies or procedures or anything. It's going to provide advice and counsel to the commissioner in the carrying out of the commissioner's responsibilities for all these things. So it isn't going to do anything about an anti-retaliation policy or reviewing disciplinary actions. It's going to advise you on carrying out those responsibilities, but not establish. Is that the way I read this?
Yeah, but again, there's nothing that stops the commissioner from asking that group to help them with. And look, retaliation is an issue. I mean, right. I just dealt with an issue today that clearly I pushed back with supervisory staff around what appears to me to be a retaliatory step towards an employee. And I pushed back on it. And so what I see this commission doing is holding the commissioner of corrections more accountable for what they're doing inside the organization.
Yeah.
It's a set of eyes that don't exist now. And I can just tell you, my experience is that it works very effectively if the commissioner is working in concert with a commission like that.
Yeah. I just withdrew my G about the looking at the current policies and procedures, because that is already there in D. It says employees' adherence to department policies and procedures. So I think I missed that before. Senator Clarkson?
Yeah, I'd like to go to including Commissioner Baker's, one of the biggest challenges we face in corrections, which is retention. I mean, it's not really mentioned here. There are other things that are mentioned, but I think we need to add that key challenge they face, which is, and it sort of goes to what Steve was talking about, which is, the churn of the superintendents. Where do they go? But how are we not, looking at the retention challenge that this department faces? I mean, I think one of the highest retention challenges in the state, if not the highest.
I would be fully supportive of that, Senator.
I will just say, Senator, that occupy a significant portion of the conversations that we had with folks at all levels, from management down to corrections officer 1, was the question of retention.
So if we added a section in here about reviewing staffing needs, working conditions, and recruiting and retention.
And morale. Yeah.
Well,
which
yeah. I mean, all of these things reviewing all of these things would contribute to morale.
Yeah. And if the commission is going to be a really productive advisor partner for the commissioner, they need to be able to look at all the elephants in the room. Those are a lot of the elephants in the room.
Can we agree that we would?
I just need to step away for 1 minute. I'll be right back.
Okay, thank you, Commissioner. Can we agree that we would add at least one more formerly incarcerated person? And I do see the issue with adding current people, I guess. I would add somebody from, and I'm not sure, like a community justice center or something
or
like
parole.
that.
I mean, parole. We don't have any parole inclusion in here, and they're such a key piece of this system.
Well, a formerly incarcerated individual could.
Right. No, I realize that that's what you're talking about, but we also don't. I don't think we have anybody from parole mentioned anywhere.
No, and
I mean, you could, an individual at large with knowledge of and experience in the correction system could be a former parole person, but parole also has a very, I mean, I agree with you that the justice center, diversion, parole, all those people have so much experience looking at this system.
Yeah, yeah. And most of this addresses inside the facilities as opposed to outside the facilities. If you look at most of the duties are advice around inside the facilities. So Steve, I see you have your hand up.
Thank you, Madam Chair. Just a couple of clarifications, if I can. I don't think we disagree with the commissioner on a form having not having an active employee on the monitoring commission. The concern we were raising was if there was going to be a serious responsibility given to this commission to make recommendations on drug testing, that our concern would be that this commission doesn't have any active members on it, and that would be an impediment to buy-in from the folks who actually work in the facilities and in the field. So I don't want to confuse the issue. We don't have any problem with the current makeup of the monitoring commission. But if they were to be assigned an issue as important as drug testing, we think one weakness of using this group would be that there are no active members there. And I want to just point out that in our collective bargaining agreement, there is no language around drug testing because the statute governs that. And our role would only be to make sure that, in the instance that this commissioner raised, our role would only be to make sure that that our member had legal counsel and was advised from a criminal defense attorney, and also that they, once they got to the employment part of the issue, that they were represented, that their contractual rights were being adhered to. But we don't bargain over drug testing because the statute prescribes is very prescriptive in how it has to be handled. So I just wanted to make that clear, and I just want to thank Senator Clarkson. We agree 100% and Senator White and the committee 100% with the language you were suggesting about morale and adding that provision in there. That's a serious problem.
Morale and retention.
So I did see somewhere in here, and I can't find it now, about contraband, and maybe
that's in part of their charge. It's in
no, that's in the investigative.
In F, I believe, under powers and duties.
Oh yeah, contraband.
I think contraband is there.
Yeah.
It's investigations of employee misconduct, the movement.
Yeah.
Contraband, which goes to.
Okay, so let's see if we can agree that we will add at least one more formerly incarcerated person here who was not incarcerated in the same facility. Is that?
Sure.
Is everybody okay with adding that?
Yes.
And then we'll add a G here, and I removed my first G about the policies and procedures, and because I think it's in D. It already says it, employees' adherence to department policies and procedures.
Yeah.
And somehow I had missed that, but add review staffing needs, working conditions, and retention issues.
Retention and morale.
Okay.
Yeah. I would name morale.
Okay. Is everybody okay doing that?
Yes.
Okay, now back to the question of drug testing. We haven't made a decision on that yet. And, yes.
Mistress Chair, I just would like to go back to and it triggered it when you said not of this facility. My sense is that this is a commission whose job is not just limited to one facility.
No, I said the former corrections person, we need to make, what I was saying was that the two formerly incarcerated people should not have both been incarcerated in the same facility.
Okay, sorry, I misunderstood you. I thought you were tying it to the Chittenden. Okay,
no.
Great. Sorry.
No.
Got it.
Does anybody else agree that we should add somebody from the the community justice system? I don't know how to do that exactly. A community justice center person? Or not?
I don't think so.
I think I'd love to, when Sarah is with us, keeping it an odd number is probably, may have value. I don't know. And I don't know if there were other people that they considered and then ended up not including because they were trying to keep it small. So by you adding that, we go to 8, right?
I'm okay either way. I don't
Madam
think
Chair,
that
can I-
it needs to be an odd number or not, because
Yeah,
they're really
no,
not going to do any voting.
Wanting to check in with Representative Coffey to see if they had discussed other, but
I'm here,
Yeah,
Senator
she's here.
Clarkson. You know, I think we were just following kind of we leaned on our colleagues in House GovOps, and it was their recommendation just to have odd numbers. But your point is well taken, Senator White, that they will probably not be voting on things. So, yeah, but just so that people understand, the CJCs get their funding from DOC, and sometimes they're fantastic people, but sometimes it can cause they can feel the pressure, like it's been coming up. So I just wanted to offer that thought. Maybe some former someone who formerly worked at a CJC.
Oh, yeah.
Yeah. So Madam Chair, I think the representative has a great point. We have contractual relationships. We have contractual relationships with the CJCs. I'd be very, very careful about that contractual relationship and how a conflict could spin out of that. So I'd be very careful about that.
How about a former member?
I think that would be great, because I think they would have terrific insights.
Anybody else? All right. So I just have a question here on on E, on page 6.
Are we in powers and duties still?
Yes, and it says maintenance of an independent reporting hotline to the state police. When you talked to us, Commissioner Baker, I understood you to say that this is an internal hotline. It's for people in the correction system to use to report.
In particular, it's at Chittenden. It's the hotline reporting at Chittenden facility, which was always a real concern of the advocacy community. And there were struggles trying to find out or find someone who would be willing to receive those calls. So as I said last time, that's how it ended up at the state police. And there was an agreement with stakeholders that that was acceptable to them. I think the reason why that's in there is certainly Representative Coffey can add more, shed some more light on it, because one of the groups that were really concerned about this was the Women's Caucus, and they were very concerned about making sure that was operational. And I think the reason why it's in here is to assure that commissioners down the road don't back out of the commitment I made, making sure that hotline is operational.
And following up on Senator Rahm's point, that we tend not to talk about the sexual assault on men in prisons. First of all, because it's hard to talk about sexual assault in general, but I think it gets really hard when you start talking about it on men. And I would wonder if we could say maintenance of facility independent reporting hotlines, so that it's clear that it's in the facility, because I didn't understand that, and that we're going to put them in all the facilities.
I think that would be great. And I assume it's for a hotline both for the residents and for the staff, or is it just for the residents? I know in the Women's Caucus it's been talked about for the residents, but just given it's not really designed for staff. It's mostly for residents, right?
That's right. It's not meant to be for staff. I guess, Senator, I would caution you. It sounds really simple, but because of the way our IT is set up, it's not simple in facilities. And every one of these facilities is different. I would caution you about, certainly the commission taking a look at the need for it, I would support. But making language that directs us to do that, we could get sidetracked doing that and get off focus on other things we should be focused on. And there are issues around, to Senator Rahm's point, there are issues around sexual abuse in other facilities. but we don't have a good gauge on that because we don't have the kind of investigative unit, which you're going to get to in a few minutes, around the PREA requirements.
So I would assume that you're asking them to look at the compliance with the Prison Rape Elimination Act is in all facilities, not just in the women's facility.
We're obligated,
Yeah.
the governor signs a letter every year saying that we're following PREA standards, because if not, every dime of federal funding is tied to that. I mean, it's
Okay.
significant.
I get that.
So the PREA is across the system, not only internally in facilities, but externally in the field where we supervise.
Okay. I'll leave that one alone for now then. Can we, I think Ameren has been taking notes here and I've been taking notes, and I know that we're going to come back tomorrow and look at what we have and see where we might go. May I make two more suggestions before we leave this today? Well,
Sure.
of course I can. I'm the chair. What is the matter with me? So if you go to section 5, first of all, I will say that judiciary has looked at section 6. So they have looked at that. And I think that they're okay with leaving it as it is. That's the sexual exploitation by a person under the supervision of a DOC employee. But on section 5, my question was, I like this investigative unit. I had 2 questions about it. I'm not sure that how the commissioner would just decide who is going to be on it. It just says shall appoint and employ sufficient staff. And I wondered if it needs to be a little more, a little clearer about who would be on there on the investigative unit, and not so prescriptive that you couldn't make the decision, but at least so that different groups of people and different were included and were considered. And then the other thing was to I'll just throw that one out first.
I would urge you to let me run the department, Senator.
Okay.
This, and I was asked before why, and this was our idea to put this in the bill. And why don't you just create an investigative unit?
Yeah.
Well, I could, but this is going to go back to Senator Clarkson's point here. I see this as a huge part of changing the culture and the accountability in the organization. And there's been, conversation today about accountability. And you need the flexibility to pick the best people possible that you can train up in these areas to do investigations. So I don't know what you're thinking, but I wouldn't want to start talking about that. It should be represented by this group or that group.
Okay.
I think it gets, this to me is a huge piece about, well, first of all, it should be open to folks that, I've started a different way of promoting inside the department. For example, people have to meet me for key positions before, and that wasn't done before. So I understand that people understand where we're trying to go as an organization. This, I would see opening it up to get the best talent in the department that fit this role. I also see it as a leadership development opportunity. We're talking about things such as potentially rotating people every 2 years through these positions, so they get some level of expertise and understanding. And so I just caution you not to make it too prescriptive.
It was just a question. Senator Collmore.
Thank you, Madam Chair. So Commissioner, would it sort of let you get inside people, but you could also reach outside current employees if you saw fit?
We like a lot of jobs in corrections, I just advertised the Office of Professional Standards and Compliance, and I got an unbelievable turnout for this. A lot of them are internal in state government, some of them are external from state government.
Okay.
Some of them are internal to corrections, some of them are external from corrections. So it would open up like that when you announce it. And again, I see it as an opportunity to build a level of expertise that we can demonstrate to everyone as in the commission and anyone that we can take care of our own business. If you're going to have the trust that needs to be had here, we have to demonstrate that we are taking a serious look at how we do business and who's held accountable. I don't disagree with Steve, and I don't disagree with Senator Ram when she was talking earlier about the lack of accountability. I don't disagree with it. And people need to be held accountable up and down, including me.
Thank you.
Thank you. That was helpful. Steve?
Thank you, Madam Chair. I think this section is going to need some more fleshing out from our perspective. We're a bit perplexed about what the role of this investigative unit will be. Is this just to produce a report for the commissioner? What's the interplay with the two existing investigative units that already exist, one in the Agency of Human Services and one in the Department of Human Resources? How will we preserve the contractual rights of our members to representation throughout this investigation, throughout this internal investigation? And we have some concerns with a process that would have the Department of Corrections investigating itself, just from a pure transparency issue. We're concerned about that. So we have a lot of questions about this particular area, and I would urge the committee to maybe think a little bit about how to have those questions answered in a way that makes it more clear how this unit is going to work with the existing investigative infrastructure that already exists, and how do we ensure that things don't get covered up internally.
All right, I think that that we will probably have to have a more in-depth conversation about that tomorrow. But I do have one other thing that I'm going to throw out here, which relates to that, and then we can on section 7, the Criminal Justice Council. I would cross off the second section. The proposal shall give the council the authority to investigate allegations of correctional, blah, 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 blah. I would cross off that and instead do something like that they shall address the relationship of the Criminal Justice Council and the CIU in terms of internal investigations, so that it's clear, so that there's some clarity there on, just as in law enforcement, you have internal investigations that happen within departments and agencies, and then you have the Criminal Justice Council does some investigations, and what the relationship is there between the two. That's all I would, just to look at that. That's my suggestion there. Senator Ram?
I mean, I think what I'm looking for, particularly, and like you said, there's an internal and there's an independent, I think, component to this, but with an internal investigation unit, Commissioner, I wonder if you could come back with examples in other states that reveal some kind of best practice. It feels like we're standing up something that could be important, but I'm just not getting a sense of its, as Steve said, sort of its unique scope. The other thing that just, it makes me wonder is it jumps from like Prison Rape Act to policies and procedures. And are there other sort of like a Bill of Rights or some kind of enumerated federal rights that should be put here? It just feels pretty narrow. And then just says major events that might happen in corrections, which seems hard to define. So this section really just doesn't feel like it lives in a comprehensive place or aligns with what other states or the federal government wants out of this kind of unit.
When you talk at the federal government, Senator, are you talking about from the PREA standard?
Well, there's other issues besides prison rape. I feel like there's other things that are considered cruel and unusual and inhumane. And I just don't see them here besides prison rape. I feel like there's other things that the federal government wants us to pay attention to.
So just to be clear, this goes to Steve's point. This started directly out of the DMR report, where there's a recommendation. I don't have it right here in front of me, and I'm kind of doing this from memory, which should be scary for all of you, about the lack of coordination between corrections and the investigative units that do the internals. I am not proposing, to Steve's point, I am not proposing in this language that we're doing personnel investigations. I'm proposing that when somebody dies in our custody, what's happened in the past is there is zero internal review of that.
Okay.
Zero.
Kidding.
No, I'm not kidding. Okay. So there's a review done as far as medical records and medical treatment, but there is not a review done of all the circumstances surrounding it, not focused on an individual's conduct, but how do you, when we've had a suicide, how can we make the system better if we don't have an investigative process that's looking at the way we responded to an incident? We had an escape in St. Johnsbury last fall. And there was, when asked what we do for an investigation, there was none. It's not meant to focus on people's behavior. It's meant to focus on systematic responses to incidents. And the PREA, I'm more than happy to have the conversation about that. To Steve's point, the way the state does investigations, I'll give you an example, which is the best example I can give. There's an allegation against an employee, and just recently happened, a sexualized allegation against an employee. HR opens up a conduct investigation. That's clearly within the PREA guidelines from the federal government. There's certain things we have to do as a result of PREA. HR opens investigation if the employee resigns. By policy, they stop the investigation. That's in direct conflict with PREA. Direct conflict with PREA. And I'll remind you, the governor signs a letter every year to the federal government saying we follow PREA. And every dime of federal money that comes into the state is tied to that agreement. So it puts us in a very difficult position. We're not looking at creating another internal affairs personnel investigative unit. We're looking at major events. I would compare this to, and it may be dramatic, but when there's a plane crash and the federal government does a complete autopsy on how that plane crash happened, that's what I'm seeing this unit do. And this is where you start holding leadership accountable because they didn't follow policy, or the policy needs to be tweaked as a result of doing that sentinel review of a major incident department. Right now, we have major amounts of drugs coming into the facilities. I'm not saying it's the employees. And because of the lack of capacity for other people to do those investigations, they just come into the facility. We had 2 cell phones found inside Springfield about 4 months ago. Oh, well, we found two cell phones. No one knows how they got there. This is a direct threat to the security and safety of not only the folks we supervise, but the safety of our employees in facilities. So that's the idea behind this. And if we have to flush it out in language better, I'm more than happy to do that. But this directly comes from the DMR report about how long employees have to sit when these internal investigations are being done. And so the coordination of that is one piece of it, but it's more about trying to figure out what went wrong in a major event.
I think that that language can be fleshed out a little bit so that it's very clear that that's what it is. Because when I read it, that wasn't what I saw either. So I think that is very helpful to me in understanding. This is a review of the systems and the policies and procedures not a review of the individual members.
There will be investigative pieces when it comes to PREA, remember?
Yeah,
Because
yeah.
again, that's our level of expertise, not HR's level of expertise.
Right. So I think that we can change that language around a little bit. Steve?
Thank you, Madam Chair. So I think the commissioner demonstrates an important point. I mean, we're not against the Department of Corrections getting to the bottom of incidents that occur like the ones he described. I think the question we have is, for instance, in that process of reviewing a major incident in a facility, are our members going to be interrogated? Or during that interrogation, are they going to be offered the opportunity to have a union rep with them? Is the information garnered from that interrogation going to be used by HR in a human resource investigation? Will they allow our member to put on what's called a Garrity warning if there's a criminal issue involved that that is going to be turned over to law enforcement? A Garrity warning means that information cannot be turned over by the employer to law enforcement. So it gets much more complicated than I think the commissioner is describing. I mean, I think those are the questions we have, which I think need to be fleshed out. I mean, if we don't have any objection to the department trying to get to the bottom of why something occurred, but there is some unclear connection to the other investigations that will occur, whether they're criminal or whether they're employment based. How does the information garnered by that review get shared, or does it get shared? Do they have rights to representation? What happens to their contract when the department is doing this review?
Yes.
Madam Chair, I'm afraid I've got to go to a 4:30 meeting, which I think you need to as well.
Yes.
So, sorry, I'm just putting that time frame up.
Yep. I just see that it is now 4:28. And what I was going to suggest is that we come back tomorrow. Gail, what time? We have this sometime tomorrow. Am I right? I don't have a schedule in front of me. Oh, wait a minute. Maybe I do.
You do. Yes, Madam Chair, it is tomorrow and it's at 1:45.
Okay.
And I will send a reminder to everybody in the morning.
Good, thank you. So I would suggest that we if between Ameren and Damien, the suggestions that we made today, if we can have some clarity on some language on those, and then look at this final piece here and and see where we are, because we would like to get this passed out this year. I think the commissioner would be happy if we were to get it passed out. And I think there are some important things in here. And I don't know that we need to look at section 6 at all, unless somebody has something really compelling to say about it. Judiciary has already looked at it. So
do they have, we have possession of the bill. Are we going to accept their recommendations?
I would. Their recommendation, I believe, is just to do it.
Yeah, good. Right. Thank you.
So
everybody, look forward to continuing this very productive conversation.
Damien has his hand up.
Oh, sorry, Damien.
Yeah, I just wanted to ask, was there a committee decision on what to do with the drug testing or polygraph, or are you just going to hold off on that until tomorrow at this point? Because that would be the area that I'd be drafting on. So I just want to make sure that I didn't hear one. I just want to make sure.
I'm not sure that we need to, if we do anything on the drug testing at all, I would say that we just ask for a separate section that asks DOC and VSEA to work together on whether there need to be any changes to our drug policy, and if so, how. I wouldn't put it in here for the commission, I don't think, after thinking about the role of the commission.
Mhm.
I don't know where everybody else is on that.
I'd like to sort of think about it. Because I think I feel differently about the polygraph and the drug testing.
I would eliminate the polygraph, and Senator Collmore?
Yeah, I think based on what, excuse me, Commissioner Baker and Steve have said, they're already going to be talking before anything gets changed. So I don't know that we need to do anything.
Okay, I'm fine with that.
Okay, so strike section 1.
Yep.
Okay. That's the easiest answer from my standpoint. So
You just hit that little delete button.
yeah. Yep. So all right. Thank you for clarifying that. I appreciate it.
Emeren?
I have another clarifying question, actually 2 questions. There were 2 items that I heard you mention, Madam Chair, that I don't believe I heard a consensus on. One was whether to remove.
Well, if I said them, there had to be consensus. No.
One was on page 5, subdivision 2, removing the phrase "or work in any part of the state correctional system."
I think after the commissioner's testimony, I would leave that in. I would not take that out.
Okay. And then there was a suggestion around the appointing entities shall appoint members that will create a diverse commission. I heard the suggestion to add geographic diversity as well.
Yeah, that I don't think that that's so important. I always think of geographic diversity because we're way down here and you guys are way up there, but I'm sure that we don't need to add that.
Okay, and then are we adding a former criminal justice center employee to the commission?
I would like to, because I think they're an integral part of the whole system.
With that.
And another formerly incarcerated person.
Yes, I have that. I also have, just so you are aware of what's on my list, adding a new section G on page 6 to talk about reviewing staffing needs, working conditions, retention, and morale. In subdivision E on the same page, referencing that this is a facility independent reporting hotline. It doesn't currently have the word facility. And then
if that makes it clear that it's internal, because I didn't understand that. And
my other question was on page 7, actually, which you did not talk about, but if you were talking about so on page 6, the commission is really monitoring the department in certain areas. And then you have on page 7 in subdivision 3, an annual report that the commission is doing on sort of how the department is doing for those items that are being monitored on page 6. And I was wondering whether you wanted to include a specific direction about providing recommendations around the staffing retention issue. Right now, it specifies, improving compliance and eliminating instances of sexual misconduct, but it doesn't specify recommendations in that area. So I wondered if you wanted it down there as well.
Sure. If we're going to ask them to look at it, let's ask them to just come back. And it isn't to provide a report, submit an annual report. Oh, I don't care if they submit an annual report or if they just report to. Annual reports sometimes take on a life of their own. But they should report to.
Yeah, I agree. I don't think any of us want to see a 58-page report with charts and graphs and colors.
I would change that.
Yeah.
So that annually they shall report to.
Okay, and I will also need to make some changes to the implementation section 4 to stagger.
Oh, yeah.
The adding more members. So there will be some changes there as well.
Okay. Thank you.
Thank you.
Thank you very much. And Tim and Jen, thank you very much. I realize we didn't ask you too many questions afterwards, but I'm glad you were here. And sometimes our conversations get a little sidetracked here. Jen, I see you had your hand up.
Yeah, I just wanted to apologize. Tomorrow I won't be able to join you folks. Not that you need me with this great work that you're doing, but I did want to let you know that I have meetings scheduled tomorrow and won't be able to return.
Okay.
So obviously, if there's any outstanding questions, we could come back at another time.
Okay.
For me as well, but thank you all.
Thank you for your great work on the report too.
And Representative Coffey, I hope you feel better from your vaccine.
I do too. Yes.
Thank you. I appreciate that.
Go back to bed.
Yeah, I've been.
I have to